reparation measures in order to guarantee that they meet their needs and their priorities. Reparations for human rights affecting women are an important factor in the fight for justice and equality. An intersectional approach which takes into consideration the different experiences of women is indispensable to attain efficiency and equality of these different measures. Thus, ladies and gentlemen, within the purview of the development of this theme, we are indeed honored to receive personalities whose expertise in the area is recognized and appreciated by all. These personalities will share their experiences by presenting to us in a more exhaustive manner the situation on the violation of the rights of women in the world, mostly in Africa, the different approaches on reparation adopted towards the different categories of women, such as, without being exhaustive, women and the girl child in conflict situations and post-conflict situations, community women, indigenous community women, women who are victims of sexual violence, women living with a handicap, displaced women within a country, elderly women, widows. These illustrious personalities will each be given 20 minutes to express themselves, and I hope the discussions will be very enriching and will push forward the defense of the rights of women. This say, it is my pleasure to invite to the podium Honorable Commissioner Janet Salanje. Ladies and gentlemen, distinguished guests, Madam Janet Salanje is a commissioner at the African Commission on Human and People's Rights. She has held several positions in this commission, notably that of Special Rapporteur on the Rights of Women in Africa. She's still holding that position. As a managing partner of Torodo Chambers, a law firm, a reference law firm in the Gambia, Madam Janet Salanje is also in charge. She gives lectures in the Gambia Law School. She's an eminent jurist and she specializes in the rights of women. She has more than 30 years of experience, sound experience in contentious laws and in elaborating rights on the rights of women, equal rights of women and development. She has held several responsibilities on gender and development in the Gambia. Salanje has held several positions in the Gambian government. She defends human rights and pays particular attention on the rights of women. She's the founder, the first and the current advisor of the Association of Female Jurists of the Gambia. Madam Vice Chair of the Commission of the African Commission on Human and People's Rights.
allow me to stand on the existing protocols in the interest of time, because I am very conscious of the time that we have allocated, and I don't want to be seen flouting the time that is allocated. But having said that, Madam Moderator, permit me, for very good reason, to recognize in our midst the chairperson of the African Commission on Human and People's Rights, because I won't be doing justice if I don't recognize my chairperson. Chairperson, I recognize you. Madam Moderator, I will start by expressing my appreciation to the African Court for this invitation in the opening of the Judicial Year and this judicial conference. I am especially grateful that the African Court decided to focus on the theme of accessing justice for women through reparation, recognizing that the time is ripe for African human rights organs to unite in urgent dialogue to address the pressing needs for reparation, to reclaim and restore justice for the diverse realities of women across the continent, ensuring no context is left behind in the pursuit of equity and dignity. Distinguished participants, while many discussions on African women's rights rightly focus on critical issues like preventing abuse and ensuring access to rights, the critical need to address reparation for violations remains significantly underexplored. As such, as the Special Rapporteur on the Rights of Women in Africa, it is my honor and privilege to add my thoughts and insights on the right to reparation for different categories of women. From the onset, I would like to reiterate that interrogating the historical injustices and systemic violations affecting women and girls in Africa is essential for a meaningful dialogue on human rights violations, as it exposes the deep-rooted structures of oppression, highlights diverse experiences of different categories of women, and ensures that reparation and justice efforts are truly inclusive. Why do we need to interrogate the historical context of women in Africa? Distinguished Excellencies, it may be pertinent to note that the African Charter on Human and People's Rights, which is the charter and the instrument that all human rights mechanisms in Africa, the Commission, the Court, the Committee, are bound by in carrying out our work, enjoins us to take into consideration in the preamble the virtues of the historical tradition and values of African civilization, which should inspire and characterize our reflection on the concept of human and people's rights. So as we adjudicate, as we embark on dialogue, we have to put the conversation in context so that we at least know what we do. And sometimes it is not unusual for some of us to hide behind African values and the African context to deny women of their rights. So it is important for us to really interrogate the true nature of African women prior to the disruption, what I call the disruption. In an attempt to put the historical context in proper perspective, I think the professor has actually done justice to that, but I'll just reiterate that it will be pertinent to place on record the fact that before the advent of slavery and colonialism, African women held diverse and influential roles in their societies, serving as politicians, warriors, spiritual figures, traders, and custodians of cultural knowledge. In many pre-colonial African civilizations, women exercised significant autonomy. They wielded power in governance, as seen with figures like Queen Zinga of Nongo, Matamba, present-day Angola, the Nubian queens, and the women-led markets of West Africa that control economics. Professor referred to matrilineal systems in Africa, and examples can be Ghana, Malawi, and Comoros, because the ambassador of Comoros reiterated the fact that they have a matrilineal system that control economies and ensure that inheritance, at least as we deal with inheritance and leadership, are passed through the matrilineal line, reinforcing women's autonomy in family and political structures. However, coming back to reparation, The transatlantic slave trade and colonial rule violently disrupted these systems, stripping women of their agency, eroding traditional power structures, and subjecting them to gendered and racialized oppression. The imposition of patriarchal colonial legal systems, because the laws we have today are patriarchal colonial laws, further entrench inequality, relegating women to subordinate roles. In discussions on reparations, therefore, it is crucial to recognize how different categories of women, rural women, descendants of enslaved people, and those from historically matrilineal society were disproportionately affected and must be at the center of restitution efforts. True reparative justice must restore economic and social standing and the dignity and leadership role that African women historically held before these profound disruptions. Again, apart from what happened within the continent, during slavery, African women endured extreme violations that were both gendered and racialized, stripping them of their autonomy, dignity, and humanity. They were subjected to brutal physical labor, sexual violence, forced breeding, family separation, with enslavers exploiting their bodies for both economic gain and social control. Many women resisted in powerful ways, from revolt to cultural preservation. Yet, historical narratives largely ignore their suffering. These atrocities not only caused immediate harm, but also laid the foundation for enduring inequalities that continue to affect the African continent, African women, and their descendants today. I think somebody reiterated that what we refer to as historical violations are actually continuing violations, but we have to lay the context and the foundation as to what happened and why we are where we are today and why we're experiencing what we're experiencing. Yesterday, His Excellency, the President of Cabo Verde and the President of the Court reiterated the fact that a discussion on reparation is not about rewriting history. And I would like to reiterate that, indeed, a discussion for women's rights violation is not about rewriting history, but reclaiming the dignity and leadership roles that women historically held within the African continent. Coming back to present times and challenges relating to rendering justice for women to reparation, especially for violations affecting different categories of women in Africa, I will begin by indicating that reparation for women's rights violation within the continent should be considered in two broad contexts. One, conflict and post-conflict situations, addressing the harm suffered by women due to gender-based violence, displacement, sexual violence, and exploitation during armed conflicts and periods of political instability. In all my convenings, I reiterate the fact that gender-based violence that happens in armed conflict does not just happen out of context. It's the systemic and structural violation in peacetime that give rise to the escalation when we have conflict. So we have to actually interrogate the structural and systemic violation in peacetime, tackling the long-standing effects of discrimination, inequality, and socio-economic exclusion stemming from oppressive systems, patriarchal norms, and institutional failures. One of the interventions actually did mention that women are complicit in it. But my response to that, I want to take the opportunity, is that the reason why women are complicit is the way they are socialized. It's the patriarchal norms that actually lead women to be complicit and do what they do to other women. We should take things within context. So as we interrogate these two contexts, we must ensure that we have tailored approaches to ensure justice, accountability, and meaningful redress. So it is not one size fits all. I think reparation as a concept seeks to redress human rights violation. The UN High Commissioner has indicated that genuine remedy and reparation has a catalytic power over the daily lives of victims, families, communities, and entire societies. Proper reparation should consist of a balanced mix of different forms of reparation, which include restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. This has already been mentioned by the previous speaker. For women, this can include restoring displaced women to their homes and restoring liberty for women human rights defenders who face continued violation. In terms of rehabilitation, this can be actually relevant where women have experienced physical violence, sexual violence, physical and mental violence, so that at least they're actually rehabilitated, reintegrated in society. So reparation goes beyond just financial compensation. Satisfaction is also very important. This goes beyond compensation, monetary compensation. Ensuring that some form of satisfaction is reached is crucial, including public apologies where necessary, especially for women victims of digital violence or defamatory publications. Where a woman's right is violated in public, it is important that public apology is done. And of course, guarantees of non-repetition. The African Commission in 2007 adopted Resolution 111 on the right to remedy and reparation for women and girls victims of sexual violence. In the resolution, the Commission considered that rape in the context of conflict has been declared a crime against humanity and a war crime in terms of international criminal law. It also noted with concern the culture of impunity surrounding the commission of these crimes and how legal systems often break down in times of conflict, thus leaving women and girls with no access to remedies. The resolution therefore calls for states to ensure that women and girls receive reparation for sexual violence, which include compensation, rehabilitation, as well as medical and psychological support. The key message in the resolution is the participation of women and girls in elaborating, adopting, and implementing such reparation. I think this was something that was alluded to and was interrogated in the previous segment. In 2007 also, we had the Nairobi Declaration on Women and Girls' Right to a Remedy and Reparation. The declaration was co-signed by women rights advocates from all over the globe, including Africa, and it set basic principles for the right to remedy and reparation, which include non-discrimination. There's more on this, but in the interest of time, I'll just move on. I think the president was teasing me during the break that one thing I'm known for is I cannot be in any convening without alluding or making reference to the Maputo Protocol, which I have the responsibility as the custodian and to ensure that we help states to ensure the full compliance with the Maputo Protocol. It is pertinent to know that one of the major distinguishing features of the Maputo Protocol is that it recognizes the multidimensional identities of African women and does not assume that all women have the same experience. As such, it primarily protects the rights of widows, specific articles dealing with them, older women, women in distress, women heads of household find themselves in distress, rural women, women with disabilities, and women living in conflict zones. These are some of the categories identified in the protocol. However, we are all aware that women remain disproportionately vulnerable to violations, regardless of context or categorization, as systemic inequalities and gender power dynamics transcends boundaries of conflict, peace, status, or identity, thus demanding a united and inclusive response to upholding their rights and dignity. I think we got the first-hand experience of our professor, a well-empowered woman, well-educated, and the challenges she was confronted in her life. And she's not alone. All of us, imagine a lawyer or a judge going home and facing domestic violence. These are some of the challenges that we all face. So it's not about how poor you are or how educated we are. We have to deal with intersectionalities. The Maputo Protocol acknowledges that different categories of women experience discrimination and violations differently. Therefore, in our conceptualization of reparation, it is important not to take a one-size-fits-all approach. The protocol acknowledges explicitly the right to remedies and reparation where women's rights have been violated. For example, in Article 4.2 of the protocol, it provides that states should implement programs for rehabilitating victims and put in place mechanisms for reparation and prosecution of perpetrators. This read with Article 8 on equal access to justice and equal protection before the law indicates the commitment of the African human rights system to provide reparation for women violation. Apart from what we have in the Maputo Protocol, the African Commission actually takes a very proactive role in ensuring that we give life, we breathe life into the protocol. And we do so through our resolutions and our general comments to elaborate on the principles, the hard law that you have in the protocol. So we have several resolutions, and what I mentioned is one of the resolution 111. We have express guidelines dealing with sexual violence, combating sexual violence and its consequences in Africa. And these instruments speak specifically to state obligation in terms of reparation. and ensuring that reparation actually speaks to all the pertinent issues, not only monetary compensation. Sometimes it might involve law reform, putting in place institutions, putting in structures to ensure rehabilitation. But what is pertinent is that the responsibility to provide reparation for women lies with the state, whether through domestic, regional, or international mechanism. Domestic mechanisms for reparation can take different forms depending on the context of the women involved. It is common knowledge that access to justice through formal court processes is beyond the reach of many African women due to financial barriers, and in some instances, lack of decentralization of services. The states must develop reparation mechanisms that cater to different levels of women. Using traditional courts and justice delivery system can help women and bring justice to the doorstep of rural women. However, to effectively achieve this, there's a need to address the challenges of male dominance that is currently present in these traditional mechanisms and structures. What do we do? How do we ensure that women have access to reparation within the traditional court system, knowing that the majority of women, that is the only form of justice they have access to? But these structures are male-dominated. So we have to do away with the cultural norms that do not recognize women's roles in chieftaincies, as is the case in several African countries. Because for you to sit in the tribunal, you have to be a chief. And if the law says you cannot be a chief, then women are not there. The African Commission has been very proactive in tackling gender disparities across various domains, notably exemplified by a pioneering decision in a communication concerning women's entitlement to chieftaincy. This landmark ruling holds considerable weight as it influences the provision of reparation at the grassroots traditional level, especially in settings where women have long endured marginalization within leadership positions. This decision, currently awaiting adoption of the activity report by the policy organs before publication, highlights the Commission's ongoing commitment to rectify gender imbalances and promoting women's rights within traditional power structures, reflecting a significant step towards fostering gender equality and justice in African societies. Unfortunately, I apologize. I cannot give you the name of the communication and the state involved because we are constrained by the African Charter and our rules of procedure that unless our activity report is adopted, we cannot publish. But I think it is heartening to know that we have a very good jurisprudence that actually accords women the right to chieftaincy, making reference to the Maputo Protocol. This is actually very heartening. Dispensing of reparation to the formal court system, we dealt with the traditional structure, requires that states make a concerted effort to eliminate discriminating and stereotypical barriers for women's access to justice. This includes gender-sensitive training for all levels of the justice delivery system and the establishment of special mechanisms like special courts to deal with specific issues that disproportionately affect women and girls, like sexual and domestic violence. I think the training of judges, including commissioners and judges of the African Court, members of the Committee of Experts on the Rights and Welfare of the Child, is very important. You cannot just have one mechanism dealing with all the issues relevant to women. I think exposure to sensitivity, gender-sensitive training is very important. National mechanisms within the context of post-conflict should devise reparation models that specifically benefit women and girls as they experience conflict in a specific way compared to their male counterparts. Somebody asked the question, do we say males have been discriminated also? But I think we must recognize that women are affected disproportionately and actually say it out loud, as this indicated in the Commission's resolutions. Where states have failed to provide adequate and meaningful reparation, the regional mechanisms can be utilized to seek reparation for victims. Following on the interpretation of the protocol, the African Commission, the African Court, and the African Committee of Experts on Rights and Welfare of the Child should our reparation for communications and cases in which we find that there have been violations of the treaty obligations resulting in harm to victims. In this respect, I call for more communications and cases on women's rights violations, specifically on the Maputo Protocol, where domestic courts have not provided adequate remedies and reparation. The African Court has an explicit mandate to award reparation where it finds violations have occurred, even though ultimately the responsibility is always on the states to ensure implementation of these decisions. Because without implementation, these decisions will not serve any purpose. I think earlier on, the president of the court gave us a quote indicating the prevalence of gender-based violence within the continent. But it is disheartening to know that both at the national level and at the regional level, we don't have that many cases coming to us. So this is the clarion call I'm making for those of us who are here, the activists, the experts, civil society, to ensure that we actually empower women to be able to bring cases to us, because without cases, we will not be able to build the relevant jurisprudence. It is worth stating that within the Commission's communication procedures, litigants are also encouraged to not only bring forth cases, but also meticulously document violations. I fervently advocate for reparative measures from state parties. This clarion call for reparation resonates particularly strongly when considering the pervasive violations endured by women in conflict-ridden landscapes across sub-Saharan Africa. By consciously raising awareness and substantiating claims for redress, these efforts not only seek to rectify past injustice, but also pave the way for a more just and equitable future where the dignity and rights of women are upheld and protected without compromise. I think what I'm reiterating here is that sometimes the communications we receive do not speak specifically and do not itemize the claims, and we cannot invent things. So I think those of us who support litigants should actually be very proactive in ensuring that the claims are itemized so that we can grant reparation. Hence, to fortify the pursuit of justice for women in the face of violations, it is imperative to advocate for increased utilization of regional mechanisms such as the Commission, the Court, and the Committee to seek reparation for women impacted by rights violations, particularly under the Maputo Protocol, when domestic remedies fall short, and strengthen collaborative efforts between civil society, legal practitioners, and human rights advocates to amplify the voice of women affected by violations, ensuring that reparative measures are not only awarded, but effectively enforced to uphold the integrity of women's rights in Africa. Furthermore, and I think this is very important, establishing comprehensive guidelines on reparation is paramount to the Commission's communications procedure. This will rectify the inconsistencies in its decisions regarding compensatory measures. Recognizing the significance of this endeavor, the Commission acknowledges and draws insights from the African Court's fact sheet in filing reparative claims and its comprehensive study on the law and practice for reparation for human rights and violation. The imperative need for harmonized guidelines between the Commission, the Committee, and the Court is underscored by our shared commitment to addressing human rights violations and our collective quest to reinforce and strengthen complementarity between the organs. The alignment of these guidelines ensures a cohesive and coordinated approach towards addressing the multifaceted challenges of providing reparation to victims of human rights abuses before us. Additionally, some of the advantages of harmonized guidelines for reparation, I just want to highlight them a little bit, because it will be difficult for litigants to come before the court and award a reparation in one sense. They come before the Commission, they get something else. They come before the committee, get something. So harmonized guidelines are very useful, and this is a recommendation I would like to make, because it endears consistency and predictability, so that when you approach these mechanisms, you are assured with clear and unified standards, which ensures consistent application for reparation, reducing disparities in response to similar violations across the continent. We also ensure victim-centered frameworks. Whatever guidelines we have should be victim-centered, because victims' voices must be heard and should be at the center of any reparation framework we put in place. Enhance accountability, enhance cooperation between the three human rights mechanisms so that we can share best practice, jurisprudence, and resources to streamline reparation processes and ensure effective implementation. I think this is something we have to reinforce. We talk about complementarity, but complementarity is not about just transferring cases. Aligning our processes also is so very important. Aligning our frameworks is so important because it reinforces the fact that it's one human rights mechanism, so that at least women are assured of consistency and coherence when they approach this, our mechanisms. And of course, alignment with international standards also is also very important when we actually come together. But of course, contextualizing them and adapting them in the context of our charter and the instruments that we have. And finally, having harmonized framework will ensure empowerment of women and especially marginalized groups, because we're talking about women in different contexts. Standardized processes can address systemic discrimination and ensure that women and other marginalized groups receive adequate and equitable remedies. Finally, I will conclude by saying that by fostering consistency, efficiency, and fairness, A harmonized framework enhances the effectiveness of the African human rights mechanism, strengthens justice for victims, and upholds the principle of justice, fairness, and accountability in the pursuit of remedying human rights violations within the continent, and in particular, women's rights violations. I thank you all for your kind attention.
Merci infiniment, honorable commissaire et vice-présidente de la Commission africaine des droits de l'homme.
Of the African Commission on Human and People's Rights. Ladies and gentlemen, we'll follow on with the next expose, and afterwards you will ask your questions. The next presenter, after Commissioner we have just listened to, Commissioner Salanjai, will be Honorable Bernard Duhaime, the Special Rapporteur of the United Nations on the promotion of truth, justice, reparation, and guarantees of non-repetition. Unfortunately, we'll have to follow him online because he was able to make it to Arusha for this meeting. Professor Duhaime is a professor on international law in the Faculty of Science and Political Science in the University of Quebec in Montreal. He specialized in international humanitarian law and international human rights law. He has published many books and has presented many conferences across the world. He's a researcher, associate researcher in the Geneva Academy, and a member of the University Board on Human Rights and the Center for Persons and Pluralism of Universities, as well as a member of the editorial committee on torture. Ladies and gentlemen, we'll follow Mr. Bernard Duhaime online.
Ladies and gentlemen, good afternoon and thank you to everyone for being here. I want to express my gratitude to the African Court for inviting me to speak on the critical subject of reparations for women victims of sexual and gender-based violence. As has already been shared, I am the current Special Rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence, which is a role I entered in May of 2024. The mandate was established by the Human Rights Council in 2011, and at its core, the mandate is intended to improve understanding and practices around transitional justice, which, for the purpose of the mandate, is the process of addressing serious violations of human rights and humanitarian law committed during periods of armed conflict and authoritarianism, and building sustainable peace in their wake. The mandate supports a comprehensive, victim-centered approach that is grounded in international law and informed by gender perspectives, transdisciplinary insights, and the voice of historically marginalized groups. I will begin my remarks today by providing some context as to the hopes and expectations of transitional justice as envisioned by my mandate and other organs of the United Nations, including reparations specific. As the title of my mandate suggests, prosecution alone cannot address the range of collective damage done during periods of armed conflict and authoritarian rule. Instead, our vision of transitional justice recognizes that as a complement to traditional justice-focused measures, other actions must be accompanied by programs designed to promote truth, reparation, memorialization, and guarantees of non-recurrence. However, as has been recognized by my predecessors and many other actors within and outside the UN, these various measures are not simply items on a checklist. In the words of Secretary General Gutierrez, transitional justice cannot be reduced to a formulaic, technocratic, apolitical exercise. Instead, he laid out in his 2023 guidance note on transitional justice, the design of transitional justice mechanisms should seek not only to address harm, but to maximize the potential of these mechanisms. Quote, to acknowledge victims' experiences and empower them as right holders, to strengthen the level of civic and institutional trust, to enhance inclusion at individual and collective levels, to increase gender equality, and to identify root causes of conflict and abuses with a view of tackling them as part of a transformative prevention agenda. End of quote. For these reasons, I have emphasized in my recently published report before the General Assembly and the Human Rights Council the need for transitional justice mechanisms to be context-specific, victim-centered, and informed by gender perspectives, minority voices, and transdisciplinary approaches. Additionally, it's absolutely essential for transitional justice measures, especially reparation programs, to comply with all applicable international legal standards, such as the basic principles and guidelines on the rights to a remedy and reparation articulated by the General Assembly in 2005. I would like now to provide a brief overview of some of the key elements of an effective reparations program before turning to the unique challenges posed by repairing harms dealt against women and LGBTQ persons specifically. Firstly, reparation programs must be adequate, prompt, and effective. They should also be comprehensive and include different forms of reparation beyond compensation, such as measures of satisfaction, restitution and rehabilitation, and guarantees of non-recurrence. Second, prior to the design of reparation programs, they should be based on national registries of victims which are flexible and reach out widely in order to compile a comprehensive universe of victims and adequately estimate expected costs. Thirdly, the legal and institutional framework and the financial allocation for the programs must be robust and include protection from political and economic upheaval or interference. A key challenge many programs face is how to address refugees and internally displaced persons and ensure their access to adequate reparation, and this should not be overlooked when designing reparation programs to address harm against women. Victims are many times ignored during the design of these programs, and it is critical to consult with them in order to include them in the decision-making process. Guiding all the aforementioned concerns in the design and implementation of these programs is the necessity of the involvement of civil society organizations. Their role is absolutely essential. They are crucial when it comes to victims outreach, registration, documentation, and support. They are also many times tied to the communities that have experienced the most harm. When you're able to reach the victims from a point of common understanding and background, victims are more willing to open up and provide the critical information needed to provide effective reparation. Many of the earlier reparation programs for victims of gross human rights violations did not include the specific form of victimization experienced by women or consider women's needs, interests, or visions. Thus, they were ineffective in providing effective and sustainable solutions for victims. Newer approaches to reparations aim at overcoming this deficiency through the design and implementation of a gender perspective in reparation programs. The following elements are some of the typological features that a gender-focused reparation programs should entail. 1. Reparation programs should aim at providing reparations for all victims of gender-based violence and make sure to identify reparation decisions that have a differential impact between the sexes. These perspectives should also be adopted in relation to lesbian, gay, bisexual, and transgender persons. 2. Use a progressive typology with a focus on gender to analyze the various violations of human rights, including sexual violence, violence of sexual and reproductive rights, as well as the gender impact of forced displacement and other violations of both social and economic rights. The categories of victims eligible for reparations must not reproduce patterns of gender discrimination. 3. It should also adopt a presumption of related gender-specific violations or a lowered or differentiated evidentiary test. 4. It should move beyond the traditional restitutive approach to reparations to a transformative one, which aims to decrease the exclusion, inequality, and discrimination often faced by women victims. Examples of these aims include transforming women's lives in practical terms and in terms of their self-esteem, facilitating a narrowing of existing gender gaps, and promoting a new positioning of women as individuals in relation to the community and within the family. 5. It should avoid restricting the definition of the family to a legalistic or particularly rigid concept or to dominant cultural views. This should include individuals who are in a dependence relationship with the primary victims. 6. It should consider gender and its intersectionality, which entails taking into account the complexity of the damage suffered and its consequence on the daily life of women and LGBTQ persons, the potential stigmatizing effect of crimes and reparations, and the potential transformative effect of certain measures on the structure of gender exclusion. This includes realizing a drive to transform the structure of the gender exclusion to one of inclusion and acceptance. 7. It should adopt reparation programs which are flexible and creative in order to surmount administrative and socio-cultural barriers faced by women. These programs should include measures of satisfactions and apologies that are understandable and accessible to victims. They should also aim to overcome social, cultural, and administrative barriers, including with regards to the de facto and de jure ownership of property negatively affecting women and the right to identity of women and LGBTQ persons. Other elements to consider when designing gender-sensitive reparation programs include classifying relatives of the deceased or disappeared persons who are often women as victims and provide them with full reparations. Also include reparation for persons who care for relatives with disabilities due to torture. These are experienced often by women. 3. Allow children born of rape to be recognized as autonomous victims of sexual violations. Also include complex victims, those who may have been perpetrators themselves, but who have been victims of sexual and gender-based violence in the context of their imprisonment or within the non-state armed group. I would like to now specifically discuss sexual violence and its implications for reparations. Sexual violence is a scourge on our societies. The victims of sexual violence often remain invisible or ignored. There is also a stigmatizing effect specifically of sexual violence and rape. Beyond the physical and moral harm suffered, there are secondary effects including lost profits, lost opportunities, and a disruption of the life plan. The remedies for these particular losses cannot be based on sexist preconceptions and must be assessed in the reparative measures themselves. Victims of rape can have secondary effects of forced pregnancy, sexually transmitted disease, and loss of reproductive capacity. In certain countries, as in the case of Croatia, for example, reparation programs, the amount of compensation was increased in the event of aggravating circumstances due to rape. Additional secondary effects due to stigmatization include effects on the relationship of victims to their environment and to the enjoyment of economic, social, and cultural rights. They can experience rejection by their romantic partner, the inability to marry or inherit, and stigma within the community that can lead to difficulty in accessing a livelihood and may require compensation also. Additionally, in many other contexts, legislation on reparation has only arrived decades after the conclusion of the particular conflict. It is critical that for victims of sexual violence, there are spaces for safety and privacy that allow these victims to come forward. These spaces can be offered by discreet, neutral, and trusted community workers, for example, properly trained health care providers, and so forth. It is necessary that victims feel that they are being cared for in this process and that their concerns and stories will not be used against them in any way, shape, or fashion. To this point, all information provided must remain confidential. Transformative reparation for victims of sexual violence require adopting a gender approach to victims. This includes lowering the standard of evidence required for victims, stipulating specific types of treatment that they are entitled to, and the granting of priority access to some benefits. Importantly, programs must not only speak the language of inclusivity and intersectionality, they must be prepared to meet the needs of those populations when their voices are heard. In conclusion, I would like to thank again the African Court for facilitating this timely and important discussion, and I look forward to continuing this process with you soon. Thank you very much.
Nous vous remercions infiniment, professeur.
Bernard Denham, we thank you for your presentation. Ladies and gentlemen, you've just listened successively to two presentations, very rich presentations, very detailed from these two eminent presenters, the Vice Chairperson of the African Commission on Human and People's Rights and Professor Bernard Denham. We'll now move on to the questions and answer stage. You ask your question and indicate the speaker to whom it is addressed to enable her prepare and respond adequately. I must add that given the fact that Professor Denham made this presentation online, we cannot ask him questions. In that case, our questions will be limited to the speaker who is present here with us. Yes. Here. Much. Sorry, the interpreters can hardly hear we cannot hear the speaker. I'm lawyer Maliki Bratin. I'm with the Constitutional Court of Mali. I have some comments. The first observation I want to make is that I want to submit for the reflection of all these generous thoughts relating to natural protection, which is the responsibility of all men towards women. Amadou Ampateba was with the UNESCO, said, and I quote, "Of all men, we are all from a drop of blood that fell in a fertile and hidden valley." What does that mean? It does mean that the quality of women who are the mothers of humanity is inherent for the rest of us. And it is only just that all men individually and collectively commit themselves to protect any sort of violation, however minimal it might be, to women as human beings. That's the first comment I want to make. The second comment relates to the comment made by my brother from South Africa, addressed to the speaker, who unfortunately will not be able to answer the question on account of technical problems, but I hope the speaker here will be able to answer. He spoke about LGBTQ, and coming from a country of between 90 and 100% believers, Christians, Muslims, African beliefs, we feel we are shocked by reference to what we consider to be counter values, which which have been supported for about 30 years now, and which have been brought to not only international fora, but more and more there's an attempt to impose it in African countries. We refuse that. We reject that. The issue of LGBT is not an African value, and we want to say, honestly, we respectfully request from all those who respect human beings not to impose these concepts, which are honestly counter values, because more and more we realize that what is being referred to as development aid is used as a tool to constrain us to accept values that are not ours. Yes, to the protection of women, but no to the imposition of values relating to the promotion of LGBTQ. Thank you. Yes, the second row. Thank you, Madam Moderator, for giving me the floor. I'm Jafari Amazani, a lawyer in Kinshasa, Democratic Republic of Congo.
We were in Minova in 2012, a small locality, 30 kilometers from Goma. This town was the platform of the location for massive violation by armed groups. Women were raped by taking into account their status, whether they are widows, married. A community was established, North Kivu, and most of the women, an action was brought, and most of the women joined as civil parties. And at the end of the trial, out of 100 as accused persons, only 3 were convicted, and the others were acquitted for lack of evidence. For the women who were raped and who were not, to whom justice was not served, and those who were civil parties, because a woman who is raped in our society is considered an outcast, and justice showed its limitations, because the theme here is justice to women through reparation. Now, given this situation, what are the alternatives open to these women, given the inadequacy of the justice system? Thank you, lawyer. Any other question? There was a question in front here. Honorable, my comment will be simpler and specific. I just want to thank the Honorable Judge's microphone is going on and off. I'd like to thank her for the gentleman from the, we are losing the speaker. I was just saying that my comment will be brief. I just want to limit it to extending my gratitude to the first speaker, and also acknowledge the quality of the second speaker from the United Nations, and then go on to say that the question that came from the constitutionalists a while ago, the constitutionalists from Mali, I will wish to have some comments from the speaker, Madam Janet. Yes, Honorable Judge. Judge, we have taken 5 questions. Let's give the opportunity to the speaker to respond. You have the floor.
and they're not just questions as such. I'll start with the brother from South Africa. He's been very proactive. Thank you very much. This is what we like on dealing with the issue of, because we talked about how certain violations disproportionately affects women compared to men. This is not sort of supposed to undermine the fact that when it comes to slavery and the violation that was meted out to Africans as a whole, we're undermining what happened to men. It happened to men, and it happened to women, the separations. Yes, you said the men were actually used for their physique to breed because they wanted to have more slaves. But this is breeding for more slaves. But beyond breeding for more slaves, the slave masters also wreak havoc on the women that found themselves in that context. So in everything you say, we recognize the fact that when you have conflict, everybody suffers, men, women, boys and girls. But the impact that it has, addressing the intersectionality relating to women and the vulnerable status of women. And I did reiterate the fact that the challenge we have when you have all these violations is men, whether in Europe or in Africa or wherever they find themselves, there's a way they socialize, that it is normalized, the normalized violations of women. So this is the challenge we have. So a boy and a girl who finds themselves in a violent context, family context, that boy grows up different from you. Because your father said to you, are you a coward? You said, no, I'm not a coward. Then do not hit a woman. But a boy who grows up knowing nothing but seeing the father harassing and violating the mother ends up being a violator and an oppressor. And the girl who grows up in that context grows up believing that it's okay, it's normal. This is my culture and this is my tradition. So these are the issues that we have to, the balancing act that we have to do. So who suffers ultimately? Sometimes it happens within the family, sometimes it happens outside the family. And the violence is not only domestic violence. Sometimes you find within the context of the family, sexual violence also happening. And who suffers the greatest consequences? It's a question I would like to ask you. So we are not saying that boys do not suffer or that men do not suffer, but we're saying that disproportionately affects women because of all the intersectionality of rights. For example, a woman who's violated sexually becomes pregnant, drops out of school, is not able to take part in education going forward, is not able to contribute to development, is not able to take leadership roles. So it's something that happened, but the continuum of violation from a child all the way to being a woman, and its impact on other rights that the woman will have, education, health, the impact is graver on the woman. Because at the end of the day, all the young man does is to impregnate and move away. It's the woman who bears the consequences. So these are the comparisons we are making here. But we are not undermining or underrating the fact that when you have these violations, it doesn't affect men, it doesn't affect boys. But the reality on the ground, I think there was a reason why your father, with his wisdom, gave you that wise counsel. My father did the same thing to me as a young girl. And I think I became an activist because of my father. Because he actually brought me up to believe that as a woman, you need to stand up and claim what is your right. Nobody's going to give it to you. That's what he said to me. That's the reality. These are not given to you. You have to actually understand, and you need to be hardworking. So we all have different experiences. But actually, we're not saying that what happens does not affect. Yes, but we're underscoring the fact that because of the intersectionalities of rights, you're just dealing with one violation. But how does it impact on all other rights? The woman suffers more, the consequences. And I'm sure you'll agree with me going forward. And socialization is very important because earlier on you asked the question, why is it that women are complicit in some of the violations? Because when a woman is violated, it happens within the context of a mother, an auntie, a sister-in-law. But those mothers and sisters-in-law grew up in that context you're talking about. So what do they know? All they know is that this is how to treat another woman. So it's all grounded on patriarchy. So when we don't blame the women, we actually look at the root causes. Why are they behaving the way they're behaving? I think this is something that we need to interrogate going forward. When we look at the African Charter, you mentioned the issue of African values, and somebody else also mentioned it. And I did reiterate the fact that sometimes we hide behind African values and African civilization to deprive people of their rights. And I cited women's rights. That's why I went to the trouble of highlighting the status of women prior to slavery and colonialism. The fact that women had rights, and the fact that men did not have a problem with dealing with powerful women. It was the advent of the patriarchal norms. Patriarchy is not unique to Africa. Patriarchy was brought to Africa because I just cited a few examples. You have the Amazon warriors of Benin. They will go to war and the men stayed behind, and the men did not have any problem with that. So at what point did things change? So these are some of the things we need to interrogate. It's the intervention of the disruption, as I call it. It's the disruption of the social fabric that gave rise to what we believe today to be the cultural norms in Africa. So these are some of the things we have to bear in mind. But again, the Charter speaks that, to the rights of all human beings, irrespective of your orientation, irrespective of your gender, irrespective of your status. So when we look at a violation that happens, we don't interrogate what your sexual orientation is. You're a human being, aren't you? And your right has been violated. So the fact that you belong to a particular orientation, does it make it right for you to be attacked in the street, beaten up, assaulted? That's the question I throw back to you. And put yourself in the shoes of those of us who find ourselves in quasi-judicial and judicial bodies, having to deliberate and dilate on this. So it's not about promoting one gender over another, but it's also our responsibility is to ensure that the rights of all human beings are respected. I think that is very important. That is the only answer I can give in the absence of the presenter that did the presentation, because we did say that I'm going to deal with I think the gentleman from Mali, from the Constitutional Court of Mali, I just take note and endorse. I do agree with you that it is important that as human beings, and you made a quote, I think that was just a comment you were making. I endorse that, and I do agree with you. And I've responded to the issue relating to the LGBTQ, recognizing the fact that we deal with human beings, and we're not focusing on any particular over the other. And a gentleman from Kinshasa, Congo, and the challenges you have in Congo. I think you must be aware, the African Commission, because of the challenges of the massive violation of women's rights within the conflict situation in DRC, in fact, had to adopt a specific resolution addressing conflict-related sexual violence in DRC, and actually elaborating on state responsibility as to how to address matters relating to women who find themselves in conflict. That was why at the very beginning when I was making my presentation, I said when we deal with reparation, it's not one size fits all. We have to address women who find themselves in conflict, post-conflict, because you're talking about post-conflict reparation, and in political instability. If the judicial system itself, and I was very open, I said we have to start with ourselves. We have to sensitize us who adjudicate, whether we sit in the regional tribunals or we sit at the national level. Judges, even lawyers, need to be sensitized. Because the worst thing that can happen to a woman is to find yourself in a difficult sociocultural context where you don't talk about certain violations, and you are bold enough to come out in public and narrate your ordeal. And at the end of the day, you have an insensitive judge who actually gives a decision against you. It's like double jeopardy. And then you have to go back to your community. You're ostracized. So these are some of the challenges that you have. That is why, as the Special Rapporteur on the Rights of Women in Africa, my role and responsibility is to actually go at the national level and ensure that all these instruments we have in the Maputo Protocol, the African Charter, reflects the reality of the life of women at the national level. Because if we have these wonderful laws at the regional level or at the national level, and these are not implemented and do not reflect the lived realities, like you're saying, this is the lived reality of women within the continent, then it doesn't serve any purpose. So this is the challenge we are confronted with, and this is what we are trying to actually address and deal with by raising awareness at all levels of judges, lawyers, people in the community, so that you understand that a woman who's been violated is not the bad person, it's the violator who's the bad person. How do we ensure that we reinforce that in the mindset of communities? That's why sometimes when we advocate, I was having a discussion, I said some of us as NGOs, as women's rights activists, we come in settings like this, but it doesn't filter down to the communities. So the challenge and the clarion call is when we attend convenings like this, we need to go back and ensure it fixes that. It's people in the communities who come together. Violators come from communities. They don't drop from the sky. They come from communities. They're socialized. This is what they know. If your mother is being beaten every time, you're being raped somehow, when you find yourself in the battlefield, of course, what do you know? That is how you socialize, then that's what you will do. And when you have the position of dominance and you've conquered, that's why we say women's bodies are now spoils of war. They're part of the battleground, unfortunately. So you conquer, you get the women. And that is part of how you catalog who has won and who's victorious. And this is what happens in all contexts in DRC, in Sudan. What is happening in Sudan, we all know. So these are some of the challenges that we have. And this is why we're here talking about women's rights, talking about reparation for these injustices. But we recognize the fact that it is happening. And it's high time as adjudicators at the national level and at the regional level to ensure that women get their day in court and they get the justice and equality maintained. I didn't get I look at the commendation, but I didn't get the question. But thank you for the commendation. Maybe you can come back, but the interpretation was not very good. But let me get to my brother, Justice Ajay from Ghana, and to say I do agree with you. I do agree with you that beyond the traditional, what we consider traditional violations, you have emergent violations, which we all must actually speak to and we must be alive to, and we must recognize. I'm sure the gentleman from South Africa will say, but why are women doing what they're doing? They are complicit in it. Because I'm just using his analogy to say women also take part. They're the ones who come and collect the monies and get themselves. But then we deal with the root causes. Poverty. Why do they find themselves in the situation they find themselves? Lack of education, lack of knowledge, lack of awareness of sexual and reproductive health rights, the intersectionality of rights. This is what gives rise to what they find themselves in. Then here, that's why I did indicate from the onset, the state has an obligation and a responsibility to regulate that kind of situation and deal with it headlong. And this, when I say the states, it could be at the national level, but the traditional structures also need to be engaged. Because these women find themselves in rural settings and rural communities, where they find themselves in a situation where they're so destitute, because those who've gone through the experience of being a motherhood, know how difficult it is to carry a baby and then just let go of it and to use your womb as a commercial enterprise. It's not easy. But we need to deal with the root causes. We don't just deal with criminalizing the women who do it or the people who deal with it, but what is causing those women to do what they do? What is the state doing about it? So it's not only about the business of women's rights activists and judges and lawyers, but the context, systemic structures need to be addressed also. I think that's already, but I do agree with you that it's a challenge, it's a problem, and I think the trauma associated with that also is very difficult. I do agree with you. That is what I'll add. And it's something that we have to focus attention on. And as my mandate, we don't just deal with political and civil rights, we deal with sexual and reproductive health rights. And this falls within the category of sexual and reproductive health rights. And these are some more things we deal with. I think this is the last bit, but I would like Honorable George to just, the question that you asked, I didn't get. I just got the point of the commendation, but by the time you got to your question, I lost the interpretation. Oh.
Merci de me redonner la parole, Présidente, et merci beaucoup pour toutes les réponses que vous avez données.
I'm not getting. Are you getting?
En fait, j'avais dit que, je voulais dire simplement que précédemment posé.
One of the questions had already been put by our constitutionalist Malian friend on LGBTQ, and in responding to that question, I had answers to my question, but you can still add some details to what you have already said on this matter. Thank you.
Any additional clarification to make? I think the answer I gave is the mandate we have under the Charter, because as adjudicators also, if you are in doubt, just go back to your instrument that establishes you and that gives you jurisdiction to do what you do. And it tells you what is your role and responsibility in terms of implementation, application of the Charter. And the Charter talks about human beings, isn't it? African Charter on Human and People's Rights. Unless we are making a point that certain category of persons are not human beings. I hope we are not making that point here. So our responsibility as adjudicators is to deal with the rights of human beings, protection from discrimination, protection from harm, protection from sexual violence, protection from state sponsored violations, because sometimes you have state sponsored violations. So these are some of the things I just wanted to say. That, yeah. I think that.
Oui, merci. Nous allons prendre une autre série de questions. Nous commençons par le premier ici. Oui.
Hello. Okay. Merci beaucoup.
Operator. My name is Marcel Approval. I am the director, the regional director of the Office of the High Commissioner to Human Rights for East Africa, and I represent the Office of the High Commissioner to the African Union. So to begin with, I would like to set the tone of my comment, and I would like to reiterate that I am not trying to defend the rapporteur, the special rapporteur, who has an independent mandate. It is independent from my own work and my own mandate, so he can himself defend himself. And fortunately, he's with us. But I would like to talk about the question raised by my brother and colleague from Mali about the issue of LGBT. I think that in forums like this one, we must, against our own will, we should be able to ask and raise issue under the angle of rights and protection rather than under the value angle, because when we deal with value angles, in fact, the concepts are not very clear, and I believe that this will never get any consensus. So what I would like to say regarding this issue, as you said it rightly, the first responsibility of the state is to protect the rights of all citizens in a country, This is an obligation of the state, and this obligation is included and provided for the Constitution. And I do not think that under the issue or question of values, we can try to exclude a part of this population simply because they may have a given sexual orientation which is different and which we consider to be different from what we call African values. In fact, this is a debate. It is not a debate which is very much supported by everyone and every bodies in which I have worked and with which I have dealt. And when we try to broaden this interpretation in terms of bilateral cooperation and development, I will not go into these issues. I am rather talking about the protection of everyone without any discrimination. You did very well to recall it. And even our African instruments insist on the fact that the obligation of protection of everyone is a basic obligation of each and every state. So I would like to say to my brother that I would like not to enter in this value of culture and values, even if I refer to the Vienna Convention that talks about culture and value. This issue is really recognized, and each entity should understand how to implement its obligations in terms of protection of human rights. So I'm taking the floor to clarify this issue. So the debate is better when we put it within the angle of everyone's protection rather than taking it under the angle of culture and values which we cannot agree upon. So this is what I wanted to say, and I would like to repeat it. The rapporteur can himself or herself defend herself. I'm not talking on her behalf. I rather talk about on the behalf of the Office of the High Commissioner. And we have a mandate that does not discriminate anyone. It is an inclusive mandate. Thank you very much. Thank you. So we'll take two more questions. The two persons in the front.
Be in those spaces. So I'm just wondering from your experience, to what extent can a court include this sort of order that calls for substantive consultation with the victims in formulating reparations?
Merci, Madame la commissaire. Merci à Madame la modératrice. Je suis Sandrine Mignot-Mouté, profession magistrat, point focal national de la Cour en République centrafricaine. Également,
and I'm also constitutional advisor. I think that today we are meeting in this forum, and it would be useful for us to share the experience of the Central Republic on the issue of managing and handling the violations against women. I'm very pleased to hear the Commissioner who has alluded to several types of victims of violence. And when I speak about the Central Republic, everybody knows that my country experiences armed conflict, and this was for several years, and women and children are the first victims of this conflict, which make us face many challenges when we want to prosecute such violations, because on the first hand we have the International Penal Court which is following these cases, but locally we have the Special Penal Court and Tribunal that also consider these issues and the issue of reparations as well as all the concerns raised. So how to make remedy and how to compensate a victim for facts that are judged by the International Criminal Court, which is very far from Africa. So recently, the institution of Mr. Mukwege also is active in this field, but for my country, the issue of the legal and the judicial framework has to be raised. This is one. Second, we have to make a difference between a violence based on gender-based violence, and basically speaking, but also a violation, sexual violation, which is related to the conflict, which is it has another approach. So the government has established, and this is an opportunity for us to exchange experiences, and now I'm exchanging the experience of my country. So the government has established to the prosecution of tribunals specialized positions and jobs and people who are dealing with handling these sexual violences relating to conflicts. And the issue of the legal and judicial framework of reparations has to be raised. Currently, actions and lawsuits are undertaken to define this framework with the support of partners. And as the lady from Algeria raised it, the issue of reparations. Please come to the point. So the issue of the psychological and social impact on victims is very important, and for us it constitutes also a very important gap in the process, and prevents us from reaching peace and reconciliation. That was the experience of my country regarding the issue of reparation and the lack of the legal and judicial framework. Thank you very much. We which was sent to us. No, we are not going to continue with this question, with the same question. We'll continue discussing about it during during lunch. We have received a question sent by mail. It was read by Meredith. Please, Meredith. Much.
In the process of adjudication, is it, that this victim-centered approach is actually implemented? What orders can be made to ensure in the process of, is that the question? I think for me, it's not a question of an order that has been made by the court in ensuring that victims are consoled. It's in the process of arriving at a decision and quantifying or deciding what form of reparation will be appropriate, because we talk about different contexts. It's not a one-size-fits-all. In deciding which form of compensation is most appropriate, the victim must be part of the process. So one of the things I made in terms of my recommendation, that we must have a framework that expressly mention. We have that at the national level in terms of domestic violence. These days, they're victim centers. Most legislation will involve consultation of the victim. In terms of sexual offenses at the national level also, the way forward now is victim-centered, and victims are actually consulted in the process. Even for penalties that need to be imposed, sometimes victims are consulted. So this is the kind of framework I would like to have for all the human rights mechanisms, the commission, the court, and the committee. We have a uniform framework, a harmonized framework that builds this in the process of reparation and how we compute and deal with reparation. I think that's the best way of doing it and not dealing with. And like I indicated, the court actually has a mandate to reparative justice. So in doing that, by all means, have a framework that involves consulting the victims. What form do you want? Do you just want financial compensation? Do you want more? Are you looking for an apology? So the orders can actually speak to that specifically after a thorough evaluation by the tribunal. I think that answers, I hope that answers your question. Yes, you're part of the process here. The situation in Central African Republic that made a distinction between, trying to make a distinction in terms of sharing your experience. Thank you for sharing the experience in terms of what happens at the Central African Republic for us to take inspiration from. But what I find very difficult and challenging is the issue of separating GBV from conflict-related violence. For me, then you are running away from the problem because GBV, maybe you're saying that GBV is what happens during peacetime. But I did reiterate the fact that because of the systemic violations, because of the structural violations, this is what actually gives rights. And impunity also arising from GBV. That is what escalates to conflict-related sexual violence, elected-related sexual violence, because this is how people are socialized, this is what they know. So a comprehensive approach to the solution will be more useful than compartmentalizing. Yeah, because when you compartmentalize, then you open loopholes where people say, oh no, this is not conflict-related, this is just mere GBV. I think all sorts of violations must be addressed comprehensively in a comprehensive and integrated legislation. Of course, the approaches in terms of reparation will be context-specific. I agree with you, will be context-specific. But we will actually always call for a comprehensive approach. In terms of the hierarchy of rights, as we did with women's rights, I think one thing that is very clear from the onset, and Dr. Eno alluded to it in his opening remarks, and that what happened at the Beijing Conference in 1995, where it was made clear that women's rights are part of human rights. So when you're dealing with women's rights, you're not dealing with hierarchy, you're just addressing human rights violations. Women's rights are part of human rights. So this is the answer I will have to tell you. So it's not about hierarchy of rights, whether the man or the woman. Women's rights are part of human rights. And when we address women's rights issues, we are actually dealing with historical and the root conflict of violations and recognize the power dynamics that happens within the socio-cultural context that we find ourselves in. And when we address that, we're actually addressing human rights violation. That is why even the Maputo Protocol is anchored on the African Charter. We deal with human and people's rights. And it builds on Article 18, which deals with protection from discrimination. So it's not saying anything new. So I know time is against us, but I want to take this opportunity to thank all of you and to thank the African Court for the opportunity for me to come and share my insights from the African Commission as the Special Rapporteur on the Rights of Women in Africa. And I thank you, all of you, for your dialogue and participation. It has been very enriching. We've learned a lot from each other. Thank you very much.
Merci beaucoup, mesdames et messieurs distingués invités. Nous voici arrivés au terme de notre session, de notre deuxième session de la journée. En guise de conclusion, je ne ferai que répéter quelques citations que j'ai retenues depuis la journée d'hier. C'est que la finalité de la justice, c'est la réparation. Réparer, c'est investir dans l'avenir pour le fondement d'un développement durable. Mesdames et messieurs, vous avez suivi avec un grand intérêt cet exposé, cette présentation qui nous a été.
This presentation, both presentations which you made, and if I really have to judge from your patience and your presence here, we have been very much elated by our honorable speaker and the other speaker who made a presentation online. By way of approval and thanks, please give her thunderous applause. Thank you very much for your patience. We have come to the end of our session. Thank you, and hope to see you at the venue for lunch. See you soon. Oui.
Ajaro Nyakuda, the victim. In her detailed account of this incident and the ensuing trial of Georg Schmidt, German historian Rebecca Habermas, whose book title you see here on the slides, speculates why this might be the case, why the victim apparently from the documents didn't care. And she concludes that the judiciary did not seem to hold any promise for Ajaro to address her suffering adequately and to afford her a remedy. The best choice for her was therefore to show her resistance by ignoring it entirely. Unsurprisingly, she was not wrong on that because Georg Schmidt was later acquitted. This brief account, I believe, shows the challenge of reparations for violations of women's rights. In a nutshell, adequate reparations will only be available if the entire judicial machinery of human rights adjudication is adequate to address the violation and provides a gratifying experience to the victim. Reparations for violations of women's rights therefore hinge on a gender-specific perception and application of human rights. It's deeply entangled with how we talk about human rights in general. Now, after this introductory story, I've got two parts to my paper, and I hope I can go forward here. Let me go back one. In the first part, I will provide a little bit of theory, and the question is, what kind of reparations are we talking about? And in the second part, I will go a little bit into the different cases that I've explored in the frame of this comparative study to see how judges and how courts are actually doing, how sensitive they are towards gender issues. Now, first on the theory part, what kind of reparations are we talking about here? I think reparations is a complex issue that has many layers, and they come from different historical contexts. There's a bottom layer. In international law, reparations began at some point in modern history as war reparations, chiefly as war reparations. Who had to pay war reparations? Those who violated international law? Well, those who lost the war, who then were declared to have fought an unjust cause. And in that way, you got to reparations. So we have to consider that reparations at the beginning were not necessarily meant to provide justice, but rather to stabilize a post-war situation. The second the second layer of reparations law was added during decolonization. Decolonization, in that context, that means the process of national independence that began already in Latin America in the 19th century. And what kind of reparations had to be paid at that period? Well, reparations for investors, for members of the former colonial powers who had lost certain investments or whose property was expropriated as a consequence of reparations, as a consequence of independence. So in that respect, we've got a commercial understanding of reparations. Again, this is very strange to human rights. And the third layer of reparations is finally human rights, which comes with the rise of human rights in international law since the middle of the 20th century. So we're talking here about the most recent layer of reparations only, and the other two older layers, of course, still have an influence. For example, the case of the Torso factory, this famous case of the Permanent International Court of Justice from the 1920s, it clearly relates to the second layer. It's about giving the victim a commercially valuable substitute for the property lost. But that is not necessarily the perspective you need for human rights. So what then is the perspective on reparations that one should adopt if we're talking about human rights violations? Well, here are some treaty provisions, just provisions of the most important treaties, regional human rights treaties. There are many more treaties that I could add. And you could see from the key provisions in these treaties on reparations that they leave it somewhat open what we consider as reparations. So the African Convention in the 1989 protocol says any appropriate measure could be a reparation. Well, what is appropriate? The Maputo Protocol speaks of appropriate remedies. The Inter-American Convention speaks of satisfaction, remedies, and fair compensation, while the European Convention on Human Rights has the famous notoriously controversial term of just satisfaction in it. So that is the legal standard, and now the question is, what do we understand as that? And the main point I want to make here is that judges have an enormous discretion, and of course also commissioners in their respective legal basis, to decide what they want to consider as reparations. And, oh, damn, that was the wrong way? Okay, now here we are. And as it so happens, there's a lot of theorizing about adequate forms of reparations for human rights violations. And what comes out of that, to cut a very long story short, is that there are basically two forms of reparations. One of them is the scales. Undo a loss. Make even what has been taken away. This is the torso factory principle. But that is only half of the story. This is, let's say, the individual, somewhat commercial perspective. There is also very often an idea of property involved in that kind of compensation. It might also extend to immaterial damages, which are notoriously difficult to assess, but still, I think it follows more or less the same rules. However, there has been a lot of discussion that this form of justice, this form of commutative justice, as Aristotle would have said, is not sufficient. Because if we're talking about human rights violations, there's always an issue about changing society. Human rights are programmatic rules that are intended to lead to a further development and to justice, to make societies more just. So therefore, there is the idea that reparations should also address the structural causes of the violation at its basis. And of course, there the question is, how far do you want to go? That is very risky at times for judges to go too far in that respect, because then a legislator might say, hold on, this overlaps with our positive obligations, which we can implement via legislation, through parliaments, through government programs, etc. That is not for judges and for other court-like institutions like commissions to decide, which only adjudicate about one case. On the other hand, a judge or a commissioner might equally say that if I don't address the root cause, it will return. And reparations also means guarantees of non-repetition. So to have a guarantee of non-repetition, a point that is deeply established in the jurisprudence, you very often need to change society as such, as a whole. Okay, so basically, what you can find here is that you more or less need to think, if you follow the second idea and want to afford structural reparations, you need to think carefully about what was the cause of the violation in the first event or in the first instance. What structural causes did it have? Not just what individual prepositions were there, but what structural causes did cause the violation. And therefore, at the reparations stage, you would have to adjudicate appropriate remedies that will ultimately lead to a societal transformation on the whole. So this was my little theory part. I hope you did not find that all too boring. What I now want to do is, in the second part, to go through various issue areas. I hope I can tackle all of them in the time that was allotted to me. And I have selected these 7 issue areas that you see here, because I thought that those are areas where we see typical violations of women's rights. I hope it's fairly comprehensive. There might be some areas that we can talk about that I maybe should also include, but I think I cover a large part of the case law in this fashion. And what I did is that I looked for each of these areas into significant cases. Cases where this question of structural reparations was at stake. And then I see, how far did the judges go? Did they adopt structural reparations? Did they refrain from it? Why did they do so? Is there any form of development from individual towards structural reparations? Let me begin with, sorry, that was one too far. With family law. Yeah. So with family law, you've got a decision here. You've got many decisions actually on family law. I think I was starting with a relatively early decision of the Tanzanian High Court, since we're here in Tanzania. I thought it might be a good occasion on from 1990 on a inheritance rule of the Haya people. What inheritance rule did they have? Well, women that inherited communal property were prevented from disposing of it, from making sales of that territory, whereas men in the same situation were allowed to do it. And in that situation, the Tanzania the High Court simply said that the constitution prevails over the inheritance law and simply overruled the existing rules. I think that was a relatively straightforward case. In that case, you can simply abolish existing legislation. You don't even need to replace it and afford reparations. If that case, if that is the situation, then I think you're very lucky to. You don't really need to worry about structural reparations. You will already, by quashing the rule, afford structural reparations. Now, the second group of cases concerns cases from the European Court of Human Rights. In this case, in one case, Cusan and Fazzo against Italy, plaintiffs took offense by family name rules. So the point was that the family name was always the name of the husband, which was a bit difficult under for Italian women who could keep their own name, and they ultimately wanted that legislation to change. And the court indeed, in this case, said, well, you can only get a remedy if the legislation actually changes. So they obliged Italy to change its legislation. Unfortunately, this relatively positive ruling is not the norm for the European Court of Human Rights. You will see that in this discussion and in this study. I'm relatively critical of the European Court of Human Rights. In another case, AfCHPR against Turkey, the rule was this: a woman could not remarry within 300 days after her divorce. For obvious reasons, I wanted to ensure that she's not pregnant. However, in our age, there are other ways of finding out whether someone is pregnant or who is the father of the child. And for that reason, the court ruled that there had been a violation, so it showed a modern, gender-sensitive perspective to that rule and said, there's no legitimate reason for it anymore, but it did not really dismiss the rule. It simply said, the individual plaintiff gets compensation, and it left it with that. So you see here that it's not always as progressive as we may wish. I think a much more progressive judgment is the judgment rendered by this court here, the African court, in the case against Mali, concerning the Mali family law, where the court made detailed indications as to how the entire situation has to change, not just the legislation, but also how the gender discrimination underlying the Mali family law had to be questioned. That is, of course, overlapping with states' positive obligations, but how would you remedy that situation if not in this way? The second group of cases concerns nationality. Now, nationality laws are notoriously discriminating because very often it is easier for men to pass on their nationality, especially if we're talking about children born out of wedlock. And in this regard, I'm just pointing out some highlights here. There is this advisory opinion of the Inter-American Court of Human Rights from 1984 concerning a case of Costa Rica. Costa Rica had different rules for acquiring nationality for female versus male spouses. So women had much more difficulty to pass on Costa Rican nationality to their husbands. And that was seen as a problem. What the court did in that case was it simply declared that there had been a violation. This is a bit unfortunate because, again, it doesn't really show that the court is worried about the implementation. It leaves it entirely to the legislature to implement an appropriate change and doesn't really say anything. You might wonder, is that because it was an advisory opinion and because the people bringing the advisory opinion were not specifically asking for some specific reparations? However, I think that this is not really necessary because there are many other advisory opinions from different courts around the world where even in advisory proceedings, one could make quite detailed prescriptions for a government. A contrasting example in a contentious litigation is the case of Navakwi against Attorney General of Zambia in 1991. In that case, there existed different rules in Zambia for getting a passport for a child. Thank you. And for women, it was much more burdensome if they were not married. So every time you wanted something from the authorities, a passport, a birth certificate, you had to swear an affidavit, including the costs that are associated with getting an affidavit. For men that had children, it was much easier. They just had to declare that this is my child, just a written confirmation, so they could do it themselves. And what the High Court of Zambia did in that case was that it simply said, we are going to apply the rules applicable to fathers. So they didn't quash the discriminating rule, because then there would have been no rule how mothers would have gotten a passport. They just said, we are applying the rules that exist for men on the same basis for women. You can argue to what extent they played the legislature here, but at least they found a very effective remedy. Now, the third group of cases I want to discuss concerns the issue of violence against women, including also human trafficking. Maybe we should make a separate category for human trafficking, but there's actually quite many cases that have been discussed under this, or that I can discuss under this category. Now, one really important case, also from a reparations perspective, is the Cotton Field case, decided by the Inter-American Court of Justice. What is the Cotton Field case? The Cotton Field case relates to the city, or related to the city of Ciudad de Juarez in Mexico. And in that city, there was kind of a situation of lawlessness. Women were frequently targeted and abused by men. And in the specific case that came up to the court, 4 women were abducted, molested, abused, and ultimately killed by people on the ground. And the point is that there was this culture of impunity. No one of the authorities really seemed to care, a situation that is all too familiar for anyone who's been discussing women's rights, I suppose. And what the court did is that it revealed in its analysis of the case how there were structures within the government, within law enforcement, that prevented sensitivity, that prevented a certain attentiveness for women. There was structural ignorance of the plight of women. However, at the reparations stage, the court all of a sudden forgot about that perspective and more or less confined itself to say that it's the duty of Mexico to repair the structural problems, to repair and to end the structural discrimination, but it didn't say how. It didn't specify which steps Mexico would have to take, which, if you look at this culture of impunity, probably would not be forthcoming without some more precise advice. Nevertheless, still, for the analysis provided on the merits, I think this case deserves to be recognized. A not so good example, again, is the European Court of Human Rights. There are many cases concerning domestic violence, but also concerning human trafficking before the European Court of Human Rights. And regularly, the European Court of Human Rights has a relatively good understanding of the situation on the ground and also provides a gender-sensitive analysis to its cases. However, it always consistently only awards individual damages. It never goes into saying, like, for example, Bulgaria, you need to change that situation. Women are, if they go to a police station in Bulgaria, are systematically being discriminated. Your case is not being taken seriously. This is a big problem here. Again, I want to pour some praise on an African institution, that's the African Commission, in the case EIPR against Egypt, that concerned the treatment of journalists in case of a political conflict. And I think it is very impressive how the Commission elaborated how the treatment of female journalists had a specifically gendered perspective. How, for example, using abusive language or assaulting women is a very specific and pernicious way of violating women's rights, that in this form, male journalists in that situation could not suffer. So there was a specifically gendered perspective, and the African Commission didn't stay there, but it also included a long list of recommendations, or actually of specific obligations that Egypt had to implement. Unfortunately, Egypt has not followed up on that. The last case that is still pending is the case of Sata Lamin Banya before the ECOWAS court. The hearing, it's not yet been decided, but the hearing was in January, and from what I've heard, is that in the hearing, the ECOWAS court showed a lot of sensibility for the specific gender situation. Now, there is a number of cases on sex, sexuality, and health issues. Very important in that respect, of course, is the issue of female genital mutilation. And in that regard, I would like to point out the High Court judgment of Kenya, of the Nairobi High Court of Kenya of 2021, when someone challenged the prohibition, a medic challenged the prohibition, I'm sure you know that case, challenged the prohibition of female genital mutilation, and the court rejected that challenge, and it did so in a very gender sensitive perspective. But again, in that case, the court was lucky because it could repair it by simply rejecting the challenge. So there was not really any need for further implementation. Still, I think that these cases where a court can simply quash something are very important to provide the ground for further going judgments. And I think there is still cases pending here before this court, actually, before the ECOWAS court in the cases against Mali and Sierra Leone, and we will see what happens in these cases. There are many more cases that I could discuss here. In general, I think there is, again, a very good judgment of the Inter-American Court of Human Rights. That's in the case of RIFO against Chile. It concerned the custody of a child that was given to the father. And what the court did in that respect is he provided comprehensive reparations. He said, let's not just establish that there has been a gender-specific violation, but let's also make it a task for the Chilean government to really change its legislative practice, but also its administrative practice. That means, for example, you need to hold training courses for public officials so that they would be able to deal with these cases in a sensitive manner. I think you need to speed up a little bit. I also don't want to provide too much information overflow here. So there is yet the other issue of vagrancy laws. There is a series of decisions of that. It starts with the High Court of Zambia in 1992, who already recognized that these vagrancy laws have a disproportionate impact on women. Because women are then often sent away, in that case, from a hotel, and there was no equivalent rule for men. So there's always the expectation that, or the suspicion that when a woman is somewhere alone, especially at night, she might be a prostitute. And this is absolutely discriminating, and that in that regard, the High Court of Zambia was very outspoken on that, and also quashed, in that case, a private rule, like a private rule set up by the hotel. Yeah. So, of course, it's not only the government from which these issues might derive. And then, of course, the Palu advisory opinion taken by this court on vagrancy laws invokes many human rights provisions in that regard, especially Article 24 of the Maputo Protocol, and says that this is actually a law that not just has a disproportionate impact on women, but also on poor women. So it applies an intersectional analysis showing that how different groups of women are hit differently. In that regard, I think it's a judgment that I can really recommend. And it ordered also, in that case, Sierra Leone to change or repeal the law in question. So that is positive structural reparations. Let me go on to the penultimate area, that is war and political violence. Here, in that regard, there have been many international documents looking at that from a gendered perspective and trying to encourage institutions to also afford gender-sensitive reparations. If we look at the practice of truth and reconciliation commissions, we would probably get a very varied picture in that regard. Some of them are doing very well, others are not so. For example, Chile, again, is so to say, is following up on gender-based crimes with a gender-biased crimes with a gender-biased truth and reconciliation process. So that is not really improving things much more. Again, here I found some interesting cases from the African Commission where, for example, the case of DRC against Burundi, Rwanda, and Uganda, they recognized that the whole situation of war had a disproportionate impact on women and therefore ordered appropriate remedies. One final area is workplace discrimination. In that respect, we have got many decisions from Europe. And what I don't really understand is this, I would say, almost schizophrenic perspective of Europe. You've got very good decisions and also very effective remedies, like almost punitive damages, if it comes to things like equal pay, or if it comes to decisions like hiring. When a woman was discriminated during hiring, the employer needs to pay damages, considerable damages, several monthly salaries. That is very effective. However, Europe turns a blind eye on the discrimination suffered, especially by Muslim women. Muslim women wearing a headscarf are still considered to be lawfully discriminated against in certain situations in Europe. It's not as crude as this. There's some differences, but several courts, including the European Court of Justice, the Court of the European Union, have not taken action against that. So you see that in one region, in one and the same region, there can be high gender sensitivity on reparations in one field, and in a closely related field, they're absolutely turning a blind eye on that. Now, let me come to my results. I went through all the 7 areas with some difficulty, although. What do we learn from this? Well, first of all, women's rights are violated everywhere. There is no continent or no region that has a clean record in that regard. That is, of course, unsurprising. The next thing that I think we can see is that these structural forms of reparations are increasing over time, over the last 30, 40 decades. You see that especially in the 1990s, in the early 2000s, there were some leading cases, like the cotton field case, where structural reparations were finally recognized, so that we are moving towards a proper human rights perspective on that. And that also goes hand in hand with a sensitive perspective, a sensitive view on the plight of women. However, there is this remarkable mismatch in many jurisdictions between a gender-sensitive perspective on violations and a lack of gender sensitivity if it comes to reparations. There seems to be this mismatch. On reparations, judges are comparatively less, let's say, courageous or comparatively less ambitious than on the merits. Maybe we can discuss what the reasons might be for that. I also provided some preliminary reasoning why I think that there are differences between courts, why some courts are good in some areas and not in other areas. I think we have to look a little bit at the composition of the courts. We have to look a little bit about the context within which courts operate. I think that there's also something like court culture. If a court once has adopted a certain standard, I mean, it's of course most likely to follow its previous case law. So very often, the movement towards structural reparations really can be advanced if you have got one really good decision. I think you see that in case of this court, you see that in case of the ECOWAS court, you see that clearly in case of the Inter-American Court, that there is leading cases that really open the gates towards a much more gender-sensitive perspective on human rights and on women's rights violations. And with that, I come to my ultimate slide. Yeah. Some recommendations or some remarks or some final concluding remarks. I think we all have to be considerate of making reparations specific to gender issues. For that, I also would like to suggest to you that you think about guidelines for reparations concerning women's rights violations. That could start with best practices. Maybe this comparative study is an initial attempt to come up with some best practices. And in developing these guidelines, I would like to encourage you to be courageous, because very often it only takes one decision and you can then follow up with a whole line of jurisprudence that at some point also is easier to be accepted by states because it's not unprecedented. And the last point is that, of course, there's many good decisions on reparations, but very often implementation is a whole different thing and is lacking. And for that, it is really important to have good networks of human rights activists, of all the enormously courageous people that I met here, that are taking enormous risks to implement human rights and also to follow up on judgments. I can only commend you for that and wish you best of luck. Thank you very much for your attention.
Thank you very much, Prof, for that very insightful presentation. We've heard from different jurisdictions, from the Inter-American to the European, the African human rights system, and references has also been made to national jurisdictions. So the floor is open for questions. Okay. Yes, please. I see 2 hands. Okay, let's start with the first 2. Okay, and one at the back as well.
Thank you, Professor. Professor, I'll start on the aspect of the mismatch. What extent do you think that maybe the mismatch as regards the reparations and the merits could also be informed by the judges being cognizant of or conscious of the fact that their remedy might not necessarily be implementable, and therefore for that reason become rather conscious or cautious as to what sort of remedy to come up with? And then we've had the previous speakers addressing us on so-called historical wrongs. What role do you think the African Court and the African Commission could potentially play in addressing that particular aspect of those wrongs that have been spoken to? And then finally, what are your thoughts about how the enslaving and the colonizing countries can make reparations for the enslavement and the coloniality, but not restricting it to what is deemed to be in the past, but the continuing wrongs which are still affecting Africa and African people globally? Thank you.
Thank you, Professor. Thanks, moderator, for seeing my hand. My question was also, I tagged on the mismatch between the analysis that goes into the violation, substantive analysis that goes into the reparation, and the consequence of that really is, even as you're preparing a case, the jurisprudence to guide you on what you need to come to court with to get this type of action is quite limited. So I know you said you have your own ideas of why there's this mismatch. One thing I would like to suggest perhaps also is a shortcoming on litigants' side in terms of the preparation that goes into bringing the case, wherein more time goes into the part, the substantive violation, therefore establishing your case on fact, and less time goes into what we need to consider in framing a claim for reparations in a way that would transform society and women's lives. But in addition to that being my sense of what one of the challenges, I'd also be interested to hear what you had in mind.
Merci.
Thank you very much.
Vous avez... Est-ce que vous avez des mécanismes de suivi?
Sorry, there's the gentleman at the back. Yes, please.
Yes.
And then we'll come back for a second round.
Thank you. I apologize for not being able to stand up. I just have an operation, so I truly apologize. Thank you very much for the wonderful presentation. We all are aware that African nations are bound by both regional and international laws, no doubt. But we need to remember that African way of life has its own uniqueness, from the cultural heritage, religious beliefs, etc., etc. Now, since we approach an average citizen with what you have presented, it seems like it has been tailored from the international standpoint to a local point. Now, the approach has to be different. We do not, and we refuse to have certain laws imposed on Africa from foreign civilizations or outside civilizations out of Africa. Let me just give you a little example that I've been approached by many African citizens and asking why the African court did not take action against the French decision bounding Muslim women's of wearing the hijab in the street. If we are talking about human rights, I mean, how can we proceed if we are able to get impose laws and impose decisions on Africa? It is our turn to react, because human rights is universal law. It does not match specific countries or specific individuals. I thank you.
Thank you. We had one more question here, and then we can pass the mic to you. Ma'am? Yes, please.
Merci beaucoup. Est-ce que vous avez des mécanismes de suivi de l'exécution de ces décisions-là? Ensuite, les violences faites aux femmes, souvent, elles ne savent pas ou ont peu de connaissances du processus qui aboutit à la réparation. Avez-vous fait quelque chose dans ce domaine? Ensuite, est-ce qu'il y a l'assistance judiciaire? Nous savons dans la plupart des cas que les femmes sont pauvres et la justice, c'est des coûts, c'est des procédures. Est-ce que la Cour ici a un système d'assistance judiciaire qui permet aux femmes pauvres de pouvoir demander la réparation? Merci.
Thank you. Thank you very much for your questions. First of all, on this mismatch. Why is that mismatch? Well, let's speculate. I think that you made interesting proposals. I do believe that there is really much to the attention of the parties being focused on winning the case on the merits. As you say, Matilda, I think that this is absolutely one of the factors. I have not investigated, and I think I should do so, to what extent the care taken with respect to reparations varies with whether it is an NGO that brings the case. That might have objectives that reach beyond the case, that may have selected a specific case for its representativeness, and that wants to change the situation as a whole, rather than just an individual case. Maybe you could say that most of the cases from the European Court of Justice, which I showed as bad examples of very narrow conceptions of reparations, have not been brought by NGOs, but by the individual victim affected, who probably did not care so much about the overall situation. So that might be one factor explaining it. Are we talking here about strategic litigation? Yes or no? Another possible factor is indeed that they're thinking about reparation, about the possibility of having it implemented. Yeah, that is possible, although I would say that the data I have collected not necessarily yields this conclusion, because you have got very courageous decisions and very restrictive decisions from one and the same court concerning one and the same country, where you would expect that implementation should not really vary. So maybe it's a factor, but it's definitely not the only factor that is at play here. Concerning your second question about historical wrongs, bringing them before human rights courts, you know, I would love to see them there. Quite honestly, I would love to see them there. Of course, there's issues of standing. Can you sue a foreign government? Well, you can sue a foreign government definitely in front of the European Court of Human Rights. Maybe that is an option for someone who is interested in strategic litigation. And I think you've said already that there are good reasons to overcome limitations ratione temporis, meaning it's not easy to, or you cannot easily discard such a case by saying, oh, it's long ago, because the effects are still here today. So I think that's how you have to bring such a case, and I would love to see it. And I think that a regional human rights court would be a great idea in that respect. Maybe you can also think about bringing cases against not states, but against government institutions that have a certain subsidiary or something, anything, or some property in a formerly colonized country. Because then you have got a point where you can get it. You have someone that you can sue. So I would be super interested in any strategic litigation in that regard. That also concerns questions of enslavement, of course. I mean, there we are really talking about value extraction, and not just enslavement, also natural exploitation of natural resources. I think there you can also make a commercial case, and in that respect, it's also necessary to have a comprehensive understanding of reparations. Don't limit it only to the scales. Also think about how do we need to change the international economic order in order to have finally a balanced, fair system. I think that would really be the objective. Tie it to questions of the economic order. To the colleague who asked about the question related to the hijab. So I absolutely would also love to see cases coming on that before any court that is suitable. I absolutely think that in that regard, Europeans need to listen or to learn and to see how this question is approached here, and that it is not a problem at all, and that it is absolutely below international human rights guarantees what they are doing. I'm ashamed, and I'm lacking the understanding for things like the French law on the hijab, and there again the question is, how can you bring it before a court? Can you sue someone here at this court, for example, or at another national court in the jurisdiction that will provide an important precedent? And then, if you have international precedents by recognized courts in the region, it will be very difficult for something like the European Court of Human Rights to simply discard it and ignore it. So you need precedents, you need good precedents. By the way, I think we see here, and I hope my comparative studies showed that there is, there are some issues where some countries are advanced, taking the lead, like Latin America on violence against women. It was a huge problem there, but they had very good decisions, also by the Commission, which I could not cover here, and then also by the Inter-American Court. And that really helped to improve the situation as a whole. And that jurisprudence can then go into other regions of the world. And I think we actually have to make that process more balanced. But I think already it is happening. There is not just a... Thank you. Thank you very much. Thanks for having me. I'll not touch it anymore. So I think that is actually helping quite a lot. Concernant la dernière question posée par Madame par ici, je vous désirais répondre que...
The lady, and I must say that sometimes there are cases where a court has decided that as part of the reparation, there should be a provision for support. There should be legal aid to enable a person to be able to see the case through the national courts, international courts. These are practical issues, and that's why I'm saying that we should always discuss reparation in its structural context, not only at the individual level, not only in terms of the scale, but also as a means of transforming society in a more profound manner. Thank you.
Professor, we still have about 14 minutes. So if there are any more questions, please feel free to raise your hands. Okay, so we have one here from Sabelo. Any other questions? Okay, one at the back there as well.
Thank you so much. You made mention, and mention was made on the floor about follow-up mechanisms in as far as implementation is concerned. Are you able maybe to give examples from any jurisdiction as the manner in which the defaulting party in the form of a nation state is the consequence management procedure so that these countries actually comply, which may or may not be considered for our own African experience. Thank you.
Thanks. It's of an obvious fact of knowledge that in most of African jurisdiction, there is a challenge of conflicting laws, especially in the context of customary laws and the statutory provisions in respect to the gender equality. So considering the UN-based principles on the rights to remedy and reparation of 2005, which emphasizes on the issues of restitution, satisfaction, and guarantees of their non-repetition in respect to the reparations. So my question is, how should the states in Africa now try to operationalize these principles so as to domesticate these legal frameworks to ensure the gender-sensitive reparation in our countries? Thank you.
Thank you very much. Concerning your question of follow-up mechanisms, that's a very good question, and I think it's also necessary to collect best practices in that regard. Now, there are two examples that I want to mention. The first is that of the committees, the human rights committees within the UN framework. When they make decisions, individual decisions, or when they adopt reports, there's always a follow-up because these reports are periodic. And in the periodic report, you have the opportunity to check implementation. Of course, the downside of the committee process is that it doesn't have much bite. There might be a negative statement for the government, but many governments are in a position to sit that out and just wait for the next round. So it doesn't really have much bite. Still, there is at least some ex post control. The one institution that has, I think, a relatively good way of implementing its decisions is the European Court of Human Rights. If countries don't pay the damages that they have to pay, that will have consequences. There is an implementation procedure in the Council of Ministers, and that can lead up to the point where a country loses their votes in the Council of Europe. Now you might say that countries don't care if then just they don't vote any longer in the Council of Europe. They might also stop paying, which has happened with Russia. At some point, Russia has now left the Council of Europe or has been made to leave the Council of Europe. However, for most countries, that is not an option because with the membership in the Council of Europe and with that membership in the European Convention on Human Rights come many economic benefits. So, for example, EU membership is conditioned upon being a member of the European Convention on Human Rights. Association with the EU is conditioned upon that very same membership. And that is really what I think one has to do. One has to connect that with very specific advantages deriving from other international treaties, especially economic agreements. I think that should be done in the region. For example, if you look at the democracy and human rights clauses that the EU has included in its treaties with countries in the global south, in particular, also some African countries, that is not very valuable. First of all, it's always, something like imposing it from the outside. And secondly, it can be subject to abuse. I mean, these clauses have only been used when the EU was unhappy with a certain government in a country. So, and they never cared really about human rights. So we should discontinue that. But I think it's for the region to set up something that allows a connection between economic benefits and human rights implementation. Concerning question of the young colleague on the right to an effective remedy, how can you change deeply entrenched rules? Is Joy still here? I don't see her, right? So I spoke to her in the break, and she told me how she's approaching, or how countries are approaching the issue of FGM, or female genital mutilation. And she said, first of all, you have to understand not just the tradition that is behind it, but also the economy. That nowadays there is, so I'm just reporting what she says, she's the expert on that. There's an economy around FGM. There's, there's celebrations, there's people who do it, there's marriage benefits, so to say, that some people think they owe to that. You have to understand that. And then you have to think, what do you want to do about that? Can you find a replacement for that? Can you find a substitute that economically provides the same benefit, but just without FGM? So that is already one way. And then, of course, the second way is that you have to do a lot of convincing. Talk to people, talk to elders, tell them, inform them about medical implications. Try to change their attitudes with some reasons that they intrinsically will value, that they will think, yeah, it's important for me. It's not just because that guy here from the capital said I should do it, but it kind of resonates with my own objectives and goals. So that's just some of the examples, and that of course means you're here in a long-term game, and you really need a structural approach. Just paying damages to a victim is necessary but insufficient.
Thank you very much, Professor. Can we please give him a round of applause? And a round of applause for yourselves for the questions asked.
And for the moderator.
Thank you. We finished with 6 minutes left, so I'm going to hand over to Madam Grace. Thank you very much.
Thank you very much. So before we proceed, I would like to recognize the presence of the President of the Pan-African Parliament, who just joined us this afternoon, Chief Fortune Charumbira. You're most welcome. So we'll, yes, they're greeting you. Stand, yes. All right, so the next session is adoption of recommendations, and we request that you give us about 15 minutes for us to finalize, because we have to, there's one language pending. Yes, but the other language, Portuguese is pending. We have in Arabic and English and French, so we need a bit of time, and then also to make the copies. If we can stretch a little bit, I can see the lunch is taking its effects, but 10 minutes or so, and then we come back. 10, because we have to finalize the last version and make the copies. So let's stretch a little bit and then we reconvene in 10 minutes or so. Yes, the moderator, yes. A round of applause for moderator, Ms. Henrietta. Well done. Excellencies, dear participants, we apologize for the delay we've gone way past the 10 minutes, but we just had to check that everything is aligned in all the languages. So my colleagues have distributed the English versions. The rest are coming now shortly. Alina, where's your, yeah, okay. So the other language versions will come shortly, then we'll start. Thank you. Excellencies, ladies and gentlemen, before we proceed to the consideration of the document, what the Secretariat has done is to develop recommendations, a document called recommendations, which is going to be considered shortly. The full report will be done later in a few days, but this is capturing the outcomes of the discussions, whereas the full report has a bit more detail. So that is what is on the table for consideration. But we are bringing the other two languages. Perhaps with the guidance, we can see how to proceed. Over to the moderator. Thank you.
Merci beaucoup, Madame la modératrice de cette séance. Permettez, avant de commencer avec cette activité, que je puisse exprimer ma gratitude. Ma gratitude à l'honorable juge Imani Aboud, ainsi qu'à tout son team, qui ont permis à la Commission africaine des droits de l'homme et des peuples de venir ici à Arusha, participer à la rentrée judiciaire elle-même, ainsi qu'aux activités qui sont organisées dans le cadre de cette rentrée judiciaire, notamment cette question de la justice qui doit être rendue aux femmes par le truchement des réparations, réparations sous forme d'indemnisation, réparations sous forme de garantie de non-répétition, réparations sous forme de participation de ces femmes elles-mêmes au processus de décision qui conduisent à leur réparation, à leur indemnisation. Et je peux vous rassurer que ce n'est plus un secret. Je pense que l'ensemble des textes, des traités en matière des droits de l'homme qui organisent le système de protection et de promotion des droits de l'homme sur notre continent accorde à la femme, à nos mamans, à nos jeunes filles, une place de choix, la femme étant déjà protégée de manière générale par la Charte africaine des droits de l'homme et des peuples. La femme est au cœur d'un protocole qui lui est dédié, le protocole de Maputo, pour lequel beaucoup de femmes, dont certaines présentes dans la salle, ont contribué, n'est-ce pas, à l'adoption. La femme fait également partie des autres protocoles qui sont nés par la suite. Le protocole sur le droit des personnes âgées ne laisse pas la femme de côté non plus, ainsi que le protocole sur le droit des personnes vivant avec handicap, des personnes handicapées, fait de même. Moi, ça ne m'étonne pas. L'Afrique ayant une antériorité aujourd'hui certifiée en matière de droits de l'homme sur le continent avec la charte de Kurukanfuga, accordait déjà à la femme une place de choix. Accordait déjà à la femme une place de choix. Ce matin, quelqu'un en parlait ici, je pense, dans les 44 articles qui font partie de cette déclaration, vous verrez que la femme est nommément citée et responsabilisée, autonomisée. La femme est le pilier sur lequel nous l'avons tous étudié dans un cours, je ne sais pas s'il existe encore, la sociologie. La famille est la cellule d'une nation. La famille est la cellule d'une nation. Et j'ajoute, depuis un certain temps, la femme en est le moteur principal. la femme en est le moteur principal. Je pense honnêtement, sans peur d'être contredit, les autres nations, pour autant qu'elles ne nous prouvent pas qu'elles ont commencé à protéger la femme bien avant cette charte de Kurukanfuga, la charte mandingue dont j'ai parlé tout à l'heure, elles ont beaucoup à apprendre en venant s'inspirer sur ce que nos ancêtres, nos aïeux, il y a déjà 800, 900 ans, avaient déjà fait sur ce continent. C'est avec plaisir que j'ai accepté d'être le modérateur pour cette 4e session qui est consacrée aux recommandations, à l'adoption des recommandations. Nous ne nous sommes pas réunis pour le plaisir de nous réunir, nous nous sommes réunis parce que des différents ateliers, des différents panels qui ont été organisés par la Cour avec des très grands experts. Pour ceux qui m'ont vu là devant, j'ai pris 2 pages et demie de petites notes parce que je devrais m'en servir pour mes propres conférences ultérieures. Les experts qui se sont succédés ici ont sorti beaucoup d'idées. Maintenant, il nous appartient de les mettre ensemble sous forme de recommandations qui vont alimenter les initiatives de l'Union africaine en matière des droits des femmes, et ce, comparativement au thème de cette année qui va plancher sur les questions de justice réparatrice. Avec votre autorisation, permettez-moi de passer la parole à ma collègue qui est ici à droite, qui va passer en revue un certain nombre de recommandations qui sont sorties des 3 panels, en tout cas les plus importantes. J'ai lu le document, à mes yeux, il paraît holistique, mais comme c'est un document que nous devons adopter, permettez qu'elle présente ces recommandations-là, et puis par la suite, si vous avez des inputs à faire, à gauche ou à droite, il vous sera accordé la parole pour que vous mettiez vos inputs. Et enfin, nous pouvons applaudir ce document, l'adopter donc ensemble, l'applaudir et nous en approprier et permettre ainsi à la Cour d'apporter sa pierre, sa contribution aux initiatives de l'Union africaine pour que cette année, nous puissions avoir toutes les idées mises ensemble avec les contributions de tous les organes. Je vais donc vous passer la parole pour présenter ces recommandations. Merci.
Thank you, Professor, and good afternoon to all the participants, all protocols observed. So my team and I, composed of the young people that you see on the extreme right-hand side, Melissa and Richard, have been, since this morning, trying to put together the recommendations under the guidance of our registrar, deputy registrar. So we've collected these recommendations from the experts as well as from the delegates. I think the paper has been distributed, the recommendations have been distributed to everyone. So they are captured under 3 sessions, essentially under the 3 papers that were presented. So this is on gender mainstreaming in reparations, and on reparations on human rights violations affecting different categories of women, and then finally on violations of human rights by human rights jurisdictions. So I'm not going to read everything since you already have the presentations. So I'm just going to speak generally to provide an oversight. So the seminar has agreed, the participants, the delegates have agreed that on the thematic area on gender mainstreaming in reparations that the member states, the African Union, and other stakeholders should broaden their understanding of reparations as tools for redressing historical injustices and systemic inequalities against women and their ongoing impact. They've also agreed to call on the African Union to identify the role of the African Union member states, the African Court, and other African Union organs and institutions, national, regional, international judiciaries, including legal experts, the academia, civil society, in advancing reparatory justice in relation to women's rights. The delegates have also agreed that when it comes to negotiating on reparations, women and girls affected must be brought to the table and actively involved in decision-making in accordance to the UN Council Resolution 1325, and this process must also be victim-centered, open, transparent, and engendered using a human rights-based approach. On this particular thematic area, they've also agreed that the African Union member states and others should create a national fund for victims' compensation that is sensitive to gender issues, and finally, that states shall ensure that laws, mechanisms, and procedures are put in place to enable victims of violations, whether historical, systemic, or otherwise, to access compensation. And when it came to the second thematic area, which is reparations for human rights violations affecting different categories of women, the delegates agreed to advocate for increased utilization of regional mechanisms such as the African Commission, the African Committee of Experts, and the African Court to seek reparations for women impacted by rights violations, particularly under the Maputo Protocol when domestic remedies fall short. Additionally, to strengthen collaborative efforts between civil society, legal practitioners, and human rights advocates to amplify the voices of women affected by violations, ensuring that reparative measures are not only awarded by, but effectively enforced to uphold the integrity of women and girls' rights in Africa. And finally, on this particular issue, that the African Commission should establish comprehensive guidelines on reparations, which is also quite paramount and important to its communications procedure. Then coming to the final thematic area, which is reparations of violations of women's rights under human rights jurisdictions, the African Union, it was recommended, the delegates recommended that the African Union bring together diverse voices from different legal systems and jurisdictions, including affected communities, to share insights on approaches and practices to reparatory justice to address the inequalities against women. It was also recommended that the African Union judicial and quasi-judicial and legal organs and institutions promote collaboration and cooperation among African national and regional stakeholders on reparatory justice, and to develop recommendations for advancing reparatory justice for women's rights in Africa. Another recommendation that was made is that women and girls, victims and survivors of human rights violations, whether historical or not, must be provided with adequate reparations for harms suffered, and particularly when it comes to dealing with victims and survivors of sexual violence. It's recommended that extra care should be taken to protect their private identity and, where necessary, to avoid labeling them, which will further stigmatize them in the communities or result in drawbacks from coming forward to claim reparations. It was also recommended that legal aid, integrated assistance such as counseling, psychosocial support, medical and financial assistance following international best practice should be available to women and girls and victims, as well as victims and survivors of sexual gender-based violence. And finally, it was recommended that the assets of the perpetrators should be frozen and confiscated, and the instruments and the proceedings of crimes should be frozen, and reparations should be enforced, including foreign judgments. So this marks the end of the recommendations that were done at Arusha, Tanzania, this fourth day on 4th February 2025. So, Honorable Professor, those were the recommendations that the delegates made. Thank you.
Merci beaucoup. Je pense que vous méritez sincèrement les félicitations.
You deserve congratulations. I did not imagine that by the end of the day you'd be able to provide such a well-structured and well-written document in simple language. This is proof of the fact that you have the necessary skills. And so I really want to congratulate you and congratulate the other members of the team of the court who worked with you. So now, would like to open the floor and take inputs from those who are willing to do so. I see the Vice Chair of the African Commission on Human and People's Rights, Madam Salanjai. I'll take two from this side and I'll go to the other side, and a third person from this side. And then I'll take a third person too from the other side. You have the floor, Madam Salanjai.
Everything, but there was something I reiterated that was left out, and I believe that is within the context of the three organs, trying to have a harmonized framework and guidelines to reinforce complementarity between the organs, to ensure consistency, sharing of best practices, victim-centered approaches, and the empowerment of vulnerable women and marginalized groups. So we're saying, in fact, it generated interest, and I think Matilda from the center wanted to find out how can this happen in reality. And I know that sometimes as human rights organs, we do conduct joint studies. And I think this is one area where we can build on what the court already has and put together a framework. It's a recommendation I made, and I will humbly urge that be considered for inclusion just for completion sake, so that I think it's complete. Also, on the topic of reparation, this is a very fundamental topic, so important. It's the heart of everything that we do. And reinforcing state responsibility is also very important, because irrespective of what we do, how innovative our judgments are, our recommendations are coming from the Commission. If the states, we don't make a clarion call on the states for implementations of our decisions on reparations, then we will not attain anything. So we must reinforce state responsibility in that sense. And considering the importance of it, reinforce the role of states. And also, since, as we say, human rights is a collective responsibility, if you can also highlight the role of national judiciaries, highlight our role also as regional mechanisms generally, so that at least we break it down so that we all know what our responsibilities are. roles of NHRIs, and where do civil society actually come in. I think this will actually give a very comprehensive and complete, and anybody looking at the document will see where you fit in and what role you can play. This is just by way of a suggestion. Okay, thank you.
Merci beaucoup. Je demande au second intervenant de prendre la parole.
We'll give the floor to the second speaker and now to come back to the recommendations which have already been made. The speaker should come up with new ideas if possible. Very much. I'm Kwamba Chinge. I'm a lawyer in the Kinshasa Bar Association in Gombe. I would like to speak to the last point which was made, that is confiscation of belongings. I think confiscation of belongings stem from criminal sanctions, and based on the principle of equality of punishment, I'd like to know the belongings, the property referred to, because in our country, the Penal Code provides that property which should be seized should be those which contributed to the committing of the crime or those which stem from the crime that was committed. So, the proposal which is being made here, will it cover all the property or will it be limited, or in both cases which I've just cited? Thank you. For this quest for precision, is there any other person along the side?
I would like to maybe get some clarity on some of the items captured. If you look at on the reparations for human rights violations affecting different categories of women, or what exactly are we talking to there on point number 3, particularly where we say this would rectify the inconsistencies in its decisions regarding compensatory measures? The Commission could draw inspiration from insights of the African Court's fact sheet. Maybe it would be good to know, by virtue of being here for the first time, I'm not familiar with some of the documents referred to. Maybe if you could help to give that understanding. And then on number 3, reparations for violations of women's rights by human rights jurisdictions. We're talking there about the African Union to bring together diverse voices from different legal systems and jurisdictions, including affected communities. Would you be able to elaborate a bit on what is meant by affected communities, so that we have a clearer understanding of what we are communicating there?
Merci pour votre contribution. Decide.
Sorry, I haven't finished, sir.
Yes, please rush.
Thank you. Sorry?
Yes. Soyez rapide, terminez alors.
Thank you. No problem. And then on the bullet point number 5, under the reparations for violations, there is a mention of international best practice. Maybe if you could also elaborate a bit on that particular aspect, it would be helpful. And now looking at the preamble, we've got the recognizing that the issue, it's the second page, page number 2, recognizing that the issue of reparations for Africans due to historical injustices, it carries on. And then it talks about the fact that the African Union leadership is increasingly demanding for justice. I'd be interested to know what exactly we are referring to there as well. And then bearing in mind the next paragraph, there is mention of women of color, indigenous women, and women from marginalized communities. how exactly those relate to each other and who exactly relate talking to there. And also the next page on the aspect of the history of double marginalization of women. Thank you very much.
Merci beaucoup. Je me tourne de l'autre côté. Je commence par la juge.
Pensaula. Then I will give the floor to Madam at the back. Is there a third person from this side? Microphone, please. Over to you, Judge. Good afternoon, everyone. I would like to make a comment regarding paragraph 3. I think that it is too much to say that reparations in case of violation of women's rights by the jurisdiction of human rights. I thought that we, human rights jurisdiction, seem to be violating human rights, so we have to review the drafting. And if it is what you want to say, I think that it doesn't reflect what we mean. We cannot say that a violation is that a jurisdiction is violating human rights. It doesn't mean that justice has made a mistake, because there are remedies, and today we cannot judge a tribunal or a jurisdiction. So we have to review this paragraph 3. Thank you very much, Chair. Yes, this is very relevant. Is there anyone who would like to take the floor? Third row. Thank you for your input. As I said it before, the inputs already raised should not be repeated, because now we are behind time. But your comments are very relevant indeed, and they have been taken note of. Is there a third person from this side who would like to take the floor, please? Anyone from this side? No, I don't see any request for the floor. So what I'm going to ask now is that the 6 or 7 or 8 inputs or comments made, which seems to me very relevant, are asking for additions in case of oversight, and they also were about additions to be made. So I have noted guidelines and harmonization of the three organs in terms of reparation, the accountability of states, which goes along with the training, because before making them accountable, they should be trained to know exactly what to do in terms of reparations. Also, the role of institutions, human rights, these are partners of the African Court and also of the African Commission and other organs that deal with human rights on our continent. And this is indeed legitimate to add them in this document. The other issues are not recommendations. They are rather precisions. When we talk about property confiscation, are we talking about all properties or properties that were used in perpetrating the violations, or other categories of properties as done in the Congolese legislation? Under item or point 3 is related to precisions. Under item 5, we had requests for precisions. Another recommendation which remains the most relevant is that made by Judge Bensara, because we cannot talk about violations made by human rights jurisdiction as if it has been part of the violation of women's rights. So it seems to me very relevant to correct. So recommendations are valid, but allow me to give the floor to my colleague. Maybe she wants to add something, but it seems to me that we have received very good recommendations to be taken note of, and I will after that ask you whether you are going to adopt this document. Any other comments, please, from our side? The request for clarity in terms of about the property and other requests for clarity, these were not recommendations, they were requests of clarifications on words and expressions used in the document. The most indicated person to answer are those who have made the presentation or have moderated the panels. But I think that they are not in the room. So what we are going to ask now is to keep in touch with the Vice President of the Court, and because she has made this presentation. We'll ask her to answer, unless you want to ask other questions on issues which have not been handled in the document. So I give you 2 additional minutes for additional questions or comments. Or maybe if another panelist is here and can answer to any of the questions, he can or she can take the floor.
Thank you so much.
You made a coup in this meeting, and coup d'etat means anti-constitutional change of government. I will adopt it, but allow us to indicate that there was a debate, and you provided very valid answers because you are the author of this idea of property confiscation. You said that these are properties which
et que vous pensez que c'est bien, mérite bel et bien une confiscation. Et puis, là où je peux soutenir également votre idée, c'est que dans une assemblée comme celle-ci, c'est différentes cultures juridiques qui sont mises ensemble. Nonobstant les détails qu'il y a dans les lois, à la Commission, on a toujours cette sagesse quand un juriste qui vient d'un système juridique pose un problème, de ne pas le rejeter, parce que ça peut varier d'un système à l'autre. Nous ne disons pas que c'est des choses qui sont uniformes dans toutes les législations des 55 pays d'Afrique. Merci beaucoup. Mais comme il a demandé la parole, je vous donne la parole pour 2 minutes, and we are going to conclude now and to adopt the document. Thank you very much. We have 2 minutes if you have, again, observations to make. Thank you.
Thank you, Mr. Chair. I'll be very brief. I think on that aspect of freezing, what becomes important that could be included? Thank you.
Et ces impuretés
have several inadequacies, and we cannot solve them fully. Even if we answer to some questions, others will be pending and will remain. So the objective of this document is to feed into another document at a higher level. Now, regarding this issue, and I speaking under the control of the person who talked about it, we are talking about the execution of the judgment on our continent. But we have to be careful. The court has a mandate enabling it to monitor even conventions ratified by African states, in addition to the Charter on People's and Human Rights. So we cannot limit the judgments to issues regarding Africa only because it has a mandate to talk about other international conventions. So, and this is the difference between the two institutions. And from this point of view, I can say that this is holistic, it is general, and it should not be limited to Africa. Because now I gave the floor to Professor Joy because he was the author of this idea. Maybe he can bring precisions. Do you want to add something, Professor? Prof? The questions raised are under her control, and she's not around. If we need more clarity in this document, the document is still at the court level, so you can still exchange with her. So this leads us to the end of this very fruitful exchange, and when I see Madame Prudence coming towards me, it means that the time is very limited. So can I ask that we adopt this document without reservation and unanimously. Do you accept that we can consider this document as adopted? Yes, with amendments. Is therefore adopted, but I'm told that somebody was following through the internet from Addis Ababa, and he wanted us to mention in the document the roadmap of the PRC. So please ask him to send us exactly where to make such addition so that we can add it. We add the roadmap of the PRC, the Permanent Representative Committee. With your authorization or your permission, this document is adopted. Is there any opposition? Somebody who is opposing? Please. Thank you. So adopted with the amendments raised. This being said, my mandate is coming to its end. So before leaving this rostrum, I would like to express my thanks to the team of the court that worked on this document. I really congratulate you for the very high quality of the document in such a limited time. I was wondering whether you prepared it in advance. You prepared it since this morning, so I would like to thank those who were accompanying us in this exercise. We are at the disposal of the court for other activities next year, if God gives us life, inshallah. Thank you.
And the moderator is Honorable Justice Dr. Silva Gomez Cravid, Chief Justice of the Democratic Republic of Sao Tome and Principe. And he will call the speakers to the podium to join him.
Boa tarde a toda a gente. Eu, antes de mais, To all, good evening. First of all, I'd like to address a few words of thanks to the organizers of the event, and starting by thanking the Madam President, Honorable President of the Court, Dr. Iman Aboud, for organizing this event, which brought us all here to Arusha, and you've given us a warm welcome to make this event possible. I would also like to thank you for the topic chosen, a very relevant topic that pertains to the historical situation of our mothers, our sisters, our daughters, our wives, those who gave us birth to this mankind. Indeed, for centuries, women have been suffering from social stigmatizations at a very high level, and this stigmatization gains different shapes according to the various historical and social realities, to the point that it constitutes crimes against humanity, which should be taken into account, and we should work to end this situation in practice. Therefore, it was good for me, very good, to listen in person to all the speakers who took the floor before this panel, and who have exposed in a very clear and precise manner a number of measures that we should take into account to help address this scourge that every day it seems that it never ends. We have the feeling that we are having an increasing prevalence of women victims of social abuse, labor abuse, family abuse, and even in their workplace, women are abused, mistreated, and in some cases, there is no principle of equality that should be applied, for the simple reason that we are all human beings and we deserve the same treatment. When I saw the resolutions, I was indeed impressed by the capacity of the organizing team to make a summary of all that has been discussed, and it seemed that they went even beyond what has been discussed in a very commendable attitude. They had to take into account, in their work. Before calling the speakers for this session, I would like to ask for a big round of applause to all women in attendance and to all African women. First of all, I'd like to thank Madam Grace, our program director, doing a stellar job, and we barely understand it, but she's the one holding everything together, and extend these thanks to herself and to all the other staff members of the African Court for keeping us here very healthy, although at a very late hour, and we are indeed tired, and the room is half empty, but those in attendance are heroes. Therefore, another round of applause to the heroes that are still remaining in the room with us. Thank you. I would like to thank the African Commission on Human and People's Rights for also being part of this joint activity with the African Court, in particular the chair of the commission, the deputy chairperson of the commission, and they brought to us great lessons for which we thank you indeed. Now I'm going to talk about my panel, the panel that used for the closing of this activity, which is the solemn opening of the Judicial Year. I'd like to invite Dr. Rizam Nasuma, Senior Advisor of the AWARE GZ program. Akipovo, Regional Representative for East Africa and the African Union, the Office of the High Commissioner for Human Rights, in representing His Excellency Volker Turk, United Nations High Commissioner for Human Rights. Please, you may take your seats. And lastly, I would like to invite Malike Imbre, Counselor of the Constitutional Court of the Republic of Mali. Please, you can take the seat on my right. Ladies and gentlemen, I will start by inviting, in the order I've invited the speakers to this panel, invite Ms. Rizan Nasuna, and I'd like to say that we have 5 minutes only for each speaker. Well, as I told you earlier, Madam Grace, the program director, is taking care of this. I neglected to call someone who is my great friend, the Vice President of the African Court on Human Rights, People's Rights, Honorable Justice Modibo Sako, my brother. Please join us. I had indeed forgotten. Well, we would now start by Madam Rizan Nasuna, the Senior Advisor for GZ AWARE. You have the floor for 5 minutes. So each of us will have the pleasure to hear your statement, but 5 minutes, please. You have the floor.
I can try again. I think the microphones are also tired. Honorable Justice Modibo Sako, the Vice President of the African Court on Human and People's Rights, Honorable Professor Remy Ongoyulumbu, the Chairperson of the African Commission on Human and People's Rights, Commissioner Janet Salangi, the Vice Chairperson and Special Rapporteur on the Rights and Welfare of the Child, the Honorable Chief Fortune Zefani Charumbira, the President of the Pan-African Court, Your Lordships and Your Ladyship, Chief Justices of the African Human Rights, African Human Rights Member States, African Union Member States, Your Excellencies, members of the permanent representatives here today, Excellencies, ambassadors, and high commissioners accredited to the United Republic of Tanzania, Mr. Marcel Akpofo, Regional Representative for East Africa and the African Union, Office of the Commissioner for Human Rights, heads of organs and institutions present and in virtual attendance, honorable presidents of international and regional courts, distinguished national focal point persons of the African Court from African Union member states, distinguished chairpersons of NHRIs, honorable registrars and deputy registrars of the various jurisdictions, members of the civil society, academia institutions, academic institutions, bar associations, media fraternity, and women organizations and white networks, distinguished ladies and gentlemen. I bring to you greetings from the GIZ African Union Office, Head of Office, Dr. Tobias T, who was unfortunately not able to join us today, and the Head of Project, Ms. Sofia Galina, who heads the GIZ German Cooperation Project on Human Rights with the African Union. I wish to quickly take this opportunity to start by applauding the African Court's commitment to the advancement of the protection of women's rights in Africa, which we all know this can be attested to by the focus of this very inspiring and eventful seminar that we've just had today, of course within the context of the African Union theme of the year. The Court's commitment to ensuring justice for all and use of reparative justice as a tool for human rights protection, including of course protection of women's rights, remains a force to reckon with. As we have heard throughout the deliberations today, reparations go way beyond the immediate reasons for consequences, reasons and consequences of violations, and of course they must aim to address the political and structural inequalities that negatively shape rights of women and girls. Your Excellencies, distinguished participants, ladies and gentlemen, as it was elaborated, I think, by the Special Rapporteur earlier this morning, women's rights are women are not homogeneous groups, and therefore, as we strive to systematically address the injustices, discriminative laws, and social norms that perpetuate violations of women's rights, we believe that it is our collective responsibility to ensure that women's violations and abuses are addressed in a timely manner. And of course, we know that justice delayed is definitely justice denied. I therefore wish to reaffirm our commitment through the German development cooperation with the African Union, but particularly with the cooperation with the African human rights mechanisms, including, of course, our ongoing work with the African Court, to continue supporting the promotion and protection of women's rights, and of course, within the context of this year's theme of the year, to continue supporting the implementation of the Court's existing landmark decisions on women's rights. I conclude by saying that may we have this year and use it as an opportunity to reaffirm our collective resolve to advance the protection and promotion of the rights of all women in Africa. I thank you.
Muito obrigado, doutora Risa, pela curta e sintética apresentação.
Speech, where you have spoken about promotion of women's rights and you call for a justice, a speedy justice, not the ones that, as she said, will condition the achievement of justice, that will allow some not so good situations to take place. Since we are looking to find plausible solutions, and if justice is not done in a speed way, we won't manage to have the justice served. Following this speech, we will give the floor to Mr. Marcel Akpofo, and I want to remind him that he has only 5 minutes for the statements. Thank you.
Thank you, moderator, for giving me 5 minutes. I'll try to be within the time frame.
Mark at this important seminar on behalf of the Office of the High Commissioner for Human Rights, and speaking also on behalf of my High Commissioner. So it will be a little bit difficult for me to synthesize and then to cut it a little bit shorter because I would want to deliver it verbatim. So it is really an honor for me to take the floor today, and then I wish to congratulate the African Court on Human and People's Rights for successfully organizing this critical event and for placing a spotlight on the theme that resonates deeply with our collective commitment to the pursuit of justice, dignity, and then equality to women across Africa. I'm pleased to note that the deliberation today are in tandem with the guidance note of the United Nations Secretary General Reparations for conflict-related sexual violence, which provides that a reparation encompasses one or a combination of measures such as compensation, restitution, rehabilitation, satisfactions, and guarantee of non-repetition. They form the foundation upon which a reparation for women confronted with violations must be built if we are to realize justice that is not only meaningful but transformative. Throughout the day, as you could see, we have also explored the transformative potential of reparation as a cornerstone of justice for women who have suffered human rights violation. And then I think that throughout the day also, we have apprehended the reparation as articulated under the Article 27.1 of the protocol establishing the Africa Court, and realized and then demonstrated that they are not merely about a compensation, that they must be transformative by restoring dignity, addressing systemic inequalities, and then ensuring guarantee of non-repetition. For women, this means addressing the root cause of gender-based violence and gender-based harm, and then dismantling structural inequality. The Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW, further requires that a reparation be full, gender-sensitive, and then include material and then moral damage response. The discussion have also reaffirmed the critical need for gender-sensitive reparation that account for the realities of women, particularly those in vulnerable situations. And we have seen compelling examples, such as the African Court landmark judgment in the case that was mentioned for APDF and then the against the Republic of Mali. I think that this has been already mentioned, where the applicant challenged the family court, alleging its violation of the minimum age of marriage of the girls, the right of consent to marriage, the right to inheritance, and then the obligation to eliminate the traditional practices and conduct harmful to women and then children. And then which highlighted, as you know, as you can see, the importance of harmonizing domestic law with international and regional human rights standards. This judgment demonstrated how strategic litigation can lead to transformative remedy for women. I would wanted to jump also, but despite these developments, the underutilization of mechanisms such as strategic litigations and limited number of gender-specific cases brought before the court highlight the barriers women face in accessing justice. And these barriers include discriminating law, we have said, and amply, we've spoken about amply today, lack of awareness about legal rights, limited capacity of women's rights organization, financial constraints, and insufficient implementation of court decisions. Then addressing these challenges require collective actions and a robust partnership. And then to push for the full operationalization of the instrument like the Maputo Protocol and the African Charter of the Right of the Welfare of the Child, it is imperative to strengthen advocacy efforts and ensure political commitment and build the capacity of national institutions to integrate this effort into their legal and policy environment. And furthermore, translating these provisions into actionable and enforceable measures require collaboration with the civil society organization, legal practitioners, academics, and community leaders to drive grassroots implementation, and then to ensure mechanisms are truly transformative. Incorporating gender mainstreaming in reparations is essential. Reparation must address the root cause of gender-based harm through comprehensive measures such as restitution of land and property rights, and psychosocial support, economic empowerment program, and a legal and policy reform that prevent future violation. In parallel, enhancing monitoring mechanism for court decision is crucial to guarantee their effective implementation. We need to establish independent monitoring bodies and then strengthen the role of national human rights institutions, which contributed to greater accountability and transparency, and regular reporting data collection as public engagement will ensure that commitment made through court decision translate into meaningful and lasting outcome for women. My office, the Office of the High Commissioner for Human Rights, remain committed to supporting the African Court on Human and People's Rights and other stakeholders in advancing gender-sensitive reparations. Our collaboration with the court and other organs emphasize the importance of transformative reparation that not only redress individual harm, but also challenge and dismantle systemic inequality and restore moral dignity. As I conclude, let us reaffirm our collective commitment to ensuring that reparation become a practical reality for women across the continent. Justice for women is not only about addressing past wrong, but also shaping a future grounded in equality, dignity, and sustainable development. Let this seminar serve as a catalyst for greater collaboration, innovation, and accountability in rendering justice for women through reparation. I thank you, and then I look forward to continue our shared journey toward justice and inequality for all. God bless you. Thank you.
Muito obrigado, o senhor Markel.
Mr. Markel Akpov, who has brought to us some issues that are really important and that were debated here. And other speakers also mentioned the things he had mentioned, but he also spoke about justice and equality, and also about the recommendations approved are in alignment with the guidelines from the deliberation by United Nations, and also justice and reparation should be aligned, since we cannot have justice without reparation of the harm that was caused to the victims. We also mentioned that the conventions require that reparations from material compensation can be material, but also social, financial, and he also spoke about the judgment against Mali, and also the actions that should be taken in order to protect the victims of violations because this is a social problem and we have to tackle these issues. He also mentioned strengthening the capacity of national institutions so that they can have people with skills to follow up on these matters. And also the justice mechanism should take measures to prevent future violations. So Mr. Marcel made a summary of what was discussed here, and I would like to thank him for that. I'll now give the floor to Malik Ibrahim. You have the floor.
Chair, Honorable Dr. Silva Gomez, Honorable Justice Imani Aboud, President of the African Court, Honorable Judge Sako, Vice President of the African Court, Honorable Judges of the African Court, Human and People's Rights, Honorable Eno, Registrar of the African Court, Madam Grace, Deputy Registrar of the African Court, Your Excellencies, ladies and gentlemen, all protocols observed. Let me, from the outset, express my gratification not only for the seminar that we are closing, but also for the solemn opening session, and that was graced by the presence of His Excellency José Maria Neves, President of Cape Verde. The speeches that were made on this occasion still resound in me. They were enriching, full of wisdom, which is not surprising given the relevance of this year's theme, that is the reparations, which we are still discussing today, but in more specific terms, since we are talking about justice for women through reparation. No theme would have been more relevant if we know the importance of the rights of women in the protection of fundamental human rights, taking into account the gender dimension in reparations for violations of human rights affecting various categories of women, reparation in human rights jurisdictions for women, themes that we discussed today. I cannot forget the recommendations that have been read to you, that were read to you a while ago. I'm happy to note that these recommendations will be integrated in the initiatives of the African Union's theme of the year. And I can say that this seminar gave us the necessary tools in our fight for the respect of rights of women. Dear participants, let me take this opportunity to extend my gratitude to the Honorable Judge Imani Aboud, President of the African Court on Human and People's Rights, Honorable Judge Modibo Sako, Vice President, Honorable Judges of the African Court on Human and People's Rights, as well as the history. Without their devotion and your efforts, this seminar high-level seminar would not have taken place. I thank you from the bottom of my heart for giving me the opportunity to participate. From Mali, where I come from, we know that you are doing great work for the effective respect of human rights in Africa. Talking about my country, I cannot fail to mention the Charter of Fuga, which in its Article 44, in fact, is the first declaration on human rights because it talked about the Universal Declaration. It came at least 5 centuries before the Universal Declaration on Human Rights. UNESCO, this is documented by the UNESCO. The Mali Constitutional Court can assure you that it will rise up to all challenges to ensure the respect of human rights, particularly those relating to the rights of women, for the promotion of human rights and the attention required for women that we refer to as the mother of humanity. Vulnerabilities still remain as a result of lack of information on the process through which they can look for a reparation. The Mali Constitutional Court solidarize with your jurisdiction to ensure the real concretization of your mission to ensure the right reparation for men and women of Africa for the cruel, odious, inhuman crimes that were inflicted on them through the slave trade, neocolonialism, and even as we speak, neo-colonialist terrorism. Ladies and gentlemen, the Honorable President of Cape Verde made comments that I am happy with, because instead of repetition of the errors of the past, our quest for reparation should come with the establishment of institutions and imbued with African values of empathy and respect for humanity. Ladies and gentlemen, anyone who wants to minimize the activities of the transatlantic and trans-Saharan slave trade, of colonization, neocolonialism, would amount to arrogant attitude of those who pretend, who are happy to see their victims bleed and suffer. Ladies and gentlemen, our commitment is based on the deep conviction that humanity as a whole has to accept and be imbued with the sentiment that a suffering man is not a dancing bear, as a message said. An African woman have suffered as a result of colonialism, and I know the African man, African woman have suffered of neo-colonial terrorism which continues to impact them. The achievement of your noble mission, Madam President of the African Court on Human and People's Rights, requires our unity to fight together against things like our common borders, which the poet referred to. In conclusion, let me say just one word. Asante sana, shukran, muito obrigado, thank you. Thank you for your kind attention. Salam alaikum.
We went beyond the time, but we had a few items to raise. We understand that we're at the end of the day. The Honorable Vice President advised me that people are tired and spoke in a summarized way, but he went on a historical logic, addressed neo-colonialism, which is linked to the way people lived in the past, and emphasized the points of the president of Cabo Verde, who said brought up some bright points that we should be mentally ready to forget about colonialism, because we still feel mentally affected and colonized, although it has been over 60 years since the independence of African states. And this is an issue that concerns us, and it's good that each and every one of us should think about. We don't talk about colonialism, but we talk of neo-colonialism, but with the same pressure and the same stigma that the colonialism had in the past. So thank you very much, Doctor, for your words. And now we move to have the closure by the Honorable Vice President Modibo Sako, Justice Vice President of the African Court. He's my brother, even though he was born in a different country. And mindful that the 11 judges that compose the African Court, I didn't know all of them, but at this time, this is my third time coming to the African Court. I had the honor of getting acquainted with each and every one of them, and I'm pleased to know there are 5 women and 6 men. I think next time will be 6 ladies and 5 men, mindful that we are addressing women rights and we should give them the floor. So I applaud that. And to say that Dr. Honorable Justice, Lady Justice, came to my country. I'm in the Gulf of Guinea, close to Gabon, Nigeria, and Lady Justice Sako and other people, Dr. Grace, they came to Sao Tome, and it was an amazing experience for them to talk to the political authorities, because our country hasn't ratified the protocol, and this is something that concerns us as the judiciary, because it's high time that we should be the 35th country. So it would be the 35th country to ratify and the 9th country to adopt that marvelous clause that people don't really like. So it was a great experience by the president and vice president. They came to Sao Tome, to Cabo Verde, and you saw the consequence of being to Cabo Verde. The president of the Republic came, so I applaud both the president and the vice president of the African Court, because this was an excellent mission Having said that, I give the floor to the Honorable Dr. Budibu Sako.
Excellencies, women through reparation. Your Excellencies, invited guests, we had the honor of participating in 3 edifying sessions. The first one on gender mainstreaming in reparation. The second, focus on reparation for human rights violations affecting different categories of women. And the last and third one on reparation for violations of women's rights by human rights jurisdictions. We also had a privilege of having a summary of recommendations which will be embodied in the mechanism of the African Union. I also like to thank the moderators, the rapporteur, those who made presentations, our partners, and those who made it possible for us to have this enriching seminar. The participants who are here physically and those online. I also like to extend my gratitude to the President of the African Court on Human and People's Rights, Honorable Emmanuel, Honorable Judges here, the Registrar, the Deputy Registrar, all staff of the court, the interpreters, all those working in the background to ensure the success of this seminar. Honorable Judges, participants, that said, I would like to declare close this seminar, and we pray the good Lord to bless our court, to bless Africa and each and every one of you. Thank you.
Nothing more to add. The activities have ended, and a round of applause to all of us. A round of applause to all of us, please.